vital alternative to mediation, providing basic, cost-effective, and equitable means of dispute resolution. Advocates play a vital role in mediation, leveraging their skills to facilitate mutually beneficial agreements and championing equal access to justice. It is an honor for me to invite our esteemed dignitaries to join on the dais. Their presence is a testament to their dedication to promoting the access to justice and strengthening our judicial system. And I cordially invite Sri Honorable Justice Ravinath Tilhari Garu, Judge, High Court of Andhra Pradesh, and Executive Chairman, AP State Legal Service Authority, to come on the dais and adorn the chair as our honored guest. I request District Judge Satyavati Garu, please come on to the dais and hand out sapling to His Lordship. I also request Srimati M. Bhavita, Member Secretary, AP State Legal Service Authority, to kindly step forward and occupy the chair. I request Sri Sarath Babu, District Judge, to come on to the dais and hand over sapling to Bhavita Garu. I now invite Sri YVSDG Parthasarathy Garu, Principal District Judge Guntoru and Chairman District Legal Service Authority Guntoru, to graciously come on to the dais and assume the position. Now I request Sri G. Chakrapani Garu to come on to the dais and hand over sapling to Parthasarathy Garu. May I now request Srimati Ratnatara, MCPC Senior Trainer and today's resource person, to come on to the dais and occupy the chair. And I request Nagaraja Garu to come on to the dais and hand out sapling. I respectfully now invite Sri Arunachalam Garu, MCBC Senior Trainer and also resource person, to come on to the dais and occupy the chair. And I now request Srinivas Garu, District Judge, to come on to the dais and hand out sapling.
Madam, what are you doing?
Now I kindly invite Srimati G. Malati Garu, Secretary, AP High Court Legal Services Committee, to come on to the chair. And I request Anita Garu, District Judge, to hand over sapling to Malati Garu. Before commencement of the program, I request all the participants to raise for the national anthem. And the staff members of State Legal Service Authority, please come.
Sino.
Thank you, Amanda. Now, I request to light the lamp. As we begin the state level sensitization program on mediation, we start with a traditional ceremony of lighting of the lamp, a sacred ritual. It symbolizes the illumination of knowledge, wisdom, and understanding. Just as the lamp dispels darkness, our discussions and deliberations today aim to shed light on the benefits, techniques, and strategies of mediation, dispelling the misconceptions and fostering a deeper understanding of this alternative dispute resolution system. Thank you. Today we are going to conduct a one-day orientation session, sensitization session on the mediation, advantages, techniques and strategies to all the advocates of the 145 Mandal Legal Services Committees and also 13 District Legal Service Authorities and High Court Legal Services Committee. Advocate from all the corners of the state has attended this program. As a introductory speech, I request Srimati M. Bharti Garu, Member Secretary, AP State Legal Service Authority, to give her presidential speech.
My pranamams to Honorable Sri Justice Ravinath Tilhari Garu, Judge, High Court of Andhra Pradesh, and Executive Chairman, AP State Legal Services Authority, and my very good morning to the distinguished advocates from the entire state, from the 13 DLSCs and 145 MLSCs, and my esteemed colleagues and the master trainers and the lovely students of ACR and other law college. So I am delighted to welcome you all to this state level sensitization program on mediation. As we gather here today, I am reminded of the wise words of Mahatma Gandhi, who said, "The true function of law is to protect the weak and not to feather the nests of the strong." Mediation as an alternative dispute resolution mechanism embodies this spirit of protecting the weak and promoting justice. As members of the legal system, we have witnessed firsthand the benefits of mediation in resolving disputes efficiently and effectively. With the guidance of the Honorable Chief Justice and the Judges Committee, we have been conducting training programs for the judicial officers and advocates in collaboration with the Supreme Court Mediation and Conciliation Project Committee. Today's program is a significant milestone in our efforts to promote mediation as a movement across the state. So far, we have successfully conducted sensitization programs on mediation for advocates at the 145 MLSCs and 13 DLSA levels and also Honorable High Court. These programs have received overwhelming responses and we are encouraged by the enthusiasm and the commitment of the advocate community to embrace mediation as a valuable tool in their practice. Today's program aims to build on this momentum and provide a platform for advocates to share their experiences, learn from each other, acquire new skills and strategies in mediation. The theme of today's program, Mediation, Advantages, Techniques and Strategies, is carefully designed to equip advocates with the knowledge, skills and confidence to effectively use mediation in their practice. Our expert resource persons from MCPC will share their insights and experiences on the advantages of mediation, its techniques and strategies for success. I urge all the participants to actively engage in the discussions and ask questions, interact and share their own experiences and challenges. As we embark on this journey to promote mediation, I am confident that together we can create a culture of peace, harmony and justice in our society. Thank you all for your participation and look forward to a productive and enriching discussion. Let us work together to make mediation a cornerstone of our justice system. Thank you one and all. Namaste.
Thank you very much, madam, for lighting today's program. And now, I request today's chief guest, the Executive Chairman of AP State Legal Service Authority, Sri Navrat Tilhari Garu, Judge, High Court of AP.
The Principal District Judge and the Chairman of District Legal Service Authority, Srimati R. Ratnatara, the Senior Trainer of MCPC from Tamil Nadu, Sri E. Arunachalam, Senior Trainer of MCPC from Tamil Nadu, Srimati G. Bharti, Secretary, EPHC, LSC, the Deputy Secretary of the EP Legal Services Authority, the District Advocates, members of the legal fraternity, dear students, the distinguished guests, ladies and gentlemen. Warm welcome to all of you. So it is indeed a great privilege and honor for me to stand before you today to inaugurate this state level sensitization program on mediation for advocates. As we gather here, we are delighted by a shared commitment to advancing justice through peaceful and collaborative means. This mediation, as we all know, is fast emerging as a new paradigm for dispute resolution. and it is imperative that we, as legal professionals, equip ourselves with the knowledge and skills necessary to harness its full potential. As all of you must know, the benefits of the mediation. It is not merely an alternative to litigation. It represents a fundamental shift in how disputes can be resolved effectively. It embodies the principles of cooperation, mutual respect, and creative problem solving. This mediation is cost effective, it is time saving, and it also preserves relationships, making it an ideal choice in various types of disputes, including commercial, family, and community matters as well. Mediation also contributes to the courts alleviating the burden on the judicial system and allowing for quicker resolution of disputes. In addition, the confidentiality is maintained. This is one of the most important aspects of the mediation, that it ensures that sensitive matters are handled with discretion, making it a preferred choice in corporate and family disputes. You must be aware that the Indian Council of Arbitration on 14/1/2025 launched its rules of commercial mediation in a titled as Mediation, a critical tool for commercial dispute resolution. The introduction of the ICA mediation rules brings a significant milestone in our mission to make dispute resolution more accessible, faster, economical, and collaborative. So mediation is not just an alternative, it is a transformative tool for business seeking sustainable solutions with high compliant rates. As we all know, Section 89 of the Code of Civil Procedure, it makes mandatory for the courts to refer a dispute after they have been free for settlement either by way of arbitration, conciliation, this judicial settlement, including settlement through Lok Adalat and mediation. If the parties fail, if they fail to settle their disputes through any of the alternative modes, the suit could still be proceeded further in the courts in which it is filed. There is Section 22B of the Legal Services Authority Act 1987, which enables the establishment of permanent Lok Adalats. The Law Commission of India, in its 222nd report, has also emphasized the need for justice dispensation through alternative dispute resolution mechanism. The traditional concept of access to justice, as is normally understood, is access to courts of law. The Honorable Apex Court has also emphasized in so many cases, just to mention few, in the case of Rajasthan State Road Transport Corporation versus Krishna Kant, in Vikram Bakshi, that in our justice system resolves the dispute in a way that is private, fast, and economical. This recently, for mediation in our country, it introduces online mediation and also community mediation. So you have to understand the effect of mediation and techniques. So this program will offer valuable insights into the structured step of mediation, including pre-mediation preparation, active listening, reframing advocates to master these techniques to facilitate discussions that lead to sustainable and amicable resolutions. The process of mediation includes setting ground rules, identifying key issues, exploring interest, and working towards mutually acceptable resolutions. Now, coming to the role of the advocates as mediation facilitators, you as advocates can play a very crucial role in this process. Beyond their traditional role as legal representatives, you act as facilitators, guiding their clients through the process with objectivity and fairness. As trusted advisors, advocates have a responsibility to educate their clients on the benefits of mediation and encourage them to explore this collaborative approach. Your expertise in negotiation, communication, and conflict resolution will be instrumental in achieving positive outcomes by embracing mediation with the prolonged litigation. It is also essential to dispel the misconception that lawyers stand to lose by mediation. They would not lose by promoting mediation over litigation. On the contrary, mediation offers lawyers an opportunity to expand their practice, develop new skills, and foster long-term client relationships. So this also provides the lawyers to serve as mediators themselves for becoming the trained mediators in future. So this program will discuss the best practices that can help advocates navigate these challenges effectively, ensuring that mediation remains a viable and reliable option for dispute resolution. So this Andhra Pradesh State Legal Services Authority has been actively promoting this mediation in our state. We have established mediation centers in all the districts, and we have trained a large number of mediators. I am confident that this program will serve as a stepping stone towards empowering advocates with the knowledge and skills needed to champion mediation in our legal system. So I extend my heartfelt gratitude to the resource persons and all participants for their commitment and enthusiasm. So let us engage, learn, and contribute towards making a mediation a cornerstone of our legal practice. I wish you all the best, a fruitful and enlightening program. Thank you all.
Thank you, Milad. Lord Justice Ravinath Tilhariji, Executive Chairman of State Legal Service Authority, emphasized the crucial role of mediation in addressing the challenge of the docket explosion and pending cases, highlighting the potential pivotal role of the advocates in access to justice and in conducting mediation. Thank you, Milad. And we deeply grateful for the presence of His Lordship here, and as a mark of respect and honor, I request the Principal District Judge of Gunturu District, Pardasarthi Garu, to honor our beloved Justice Ravinath Tilhari Garu with shawl. I also request
Member Secretary, AP State Legal Service Authority, Srimati M. Babita Garu, to hand over a memento to His Lordship. Thank you, my lord. Now I request Sri G. Malati Garu, Secretary, AP High Court Legal Services Committee, to convey the vote of thanks.
Honorable Sri Justice Ravinath Tilhari Garu, Judge High Court of AP, Executive Chairman, AP State Legal Services Authority, and to all the participant officers who gathered here, my heartfelt pranams and good morning to all of you. Today, as we come to the close of this enriching inaugural session of state-level sensitization program for advocates on the topic of mediation, advantages, strategies, and techniques, I would like to take a moment to express our deepest gratitude to all the distinguished individuals who have contributed to its success. It's my privilege to extend a heartfelt vote of thanks to our esteemed guests, organizers, participants who have made this program a truly memorable experience. At this juncture, I extend my heartfelt gratitude to our Honorable Justice Sri Ravinath Tilhari Garu, Judge High Court of AP, Executive Chairman, AP State Legal Services Authority, who despite his incredibly busy schedule, graciously inaugurated this program and shared his invaluable insights on the significance of mediation in our justice system. Your presence has not only added immense value to our discussions, but has also inspired us to work tirelessly towards promoting mediation as a viable alternative dispute resolution mechanism. Thank you very much, my Lordship. I would like to express my sincere appreciation to our Member Secretary, AP State Legal Services Authority, Sri M. Babita Garu, and Deputy Secretary, Sri M. R. Rangeshwara Rao Garu, for meticulously organizing this program and ensuring its seamless execution and bringing together. Thank you very much, Madam and Amar. Your tireless efforts have made this program a resounding success. I also thank the esteemed master trainers and the Principal District Judge Guntur and team of judges of Guntur, advocates, law students, media personnel on this occasion, and to all the participants, volunteers, and well-wishers who have contributed to this program. I offer my deepest gratitude. Thank you one and all for your unwavering support and cooperation. Thank you.
Thank you, Madam. Now there will be a photograph with the Honorable Executive Chairman of State Legal Service Authority. I request all the participant advocates and the judicial officers to come in front of this seminar hall. Please. Thank you. This staff అందరూ కూడా గైడ్ చేయండి. అందరినీ ఈ హాల్ ముందు ఉన్న మెట్లు ఉన్నాయి కదా, వరుసగా అందరూ రెడీ అయిపోయిన తర్వాత మనము హైకోర్టు జడ్జి గారు వస్తారు, వారితో మనం ఒక ఫోటో దిగవచ్చు మనం. థ్యాంక్ యూ వెరీ మచ్.
లైట్ ఆన్ చేపిద్దామంటే బయటికి లైట్స్ ఆన్ చేస్తాను సార్ మొత్తం లైట్లు ఆన్ చేసారు
ఓకే
ఎస్ రెడీ 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 సార్ సార్ వన్ మోర్ చెప్పండి సార్ చూడదా జరగండి వస్తారు చూడదా జరగండి సార్ జరగండి సార్ ఓకే అండి రెడీ సార్
నెక్స్ట్ నెల్లూరు చుట్టూ తిరుగుతారా
సింగిల్ లైన్
నెక్స్ట్ నెల్లూరు
వచ్చింది
నెక్స్ట్ ప్రకాశం
చూస్తున్నారు
నెల్లూరు
ఫాస్ట్ ఫాస్ట్ ఎస్ సార్ రెడీ సార్
నెక్స్ట్
ఏం చేస్తాను
ఓకే నెక్స్ట్ ప్రకాశం
ఓకే సార్ సార్ రెడీ సార్ వచ్చారా ఫోన్ తీసుకోవాలి ఇస్తా ఉంటుంది రెడీ సార్ ఎట్లా రెడీ సార్ ఓకే రెడీ 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 ఓకే ఓకే అయిపోయింది అయిపోయింది రాదండి అక్కడ రాక వచ్చారు వచ్చారు సార్ ఎస్ రెడీ నిలబడాలి జరగండి 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 సార్ జరగండి పార్టీ ఉన్నాయి ఎస్ ఎస్ రెడీ 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 సార్ ప్లీజ్ సెటిల్ డౌన్ ఎస్ సార్ కిందకి వచ్చేసాడు శ్రీనివాస్ గారు కిందకి వచ్చేసాడు
Thank you. Next photo, basic officers. Now I request the officers of Uttara district, please come on to the desk. Officers of Uttara district. Next, సుదీర్ఘ అనుభవం ఉండి 2008 నుంచి కూడా మీడియేషన్ లో సీనియర్ ట్రైనర్ గా ఉన్నటువంటి రత్నతార గారు వచ్చున్నారు. వారిని ఈ సెషన్ తీసుకోవాల్సిందిగా ఆంధ్రప్రదేశ్ రాష్ట్ర న్యాయ సేవాధికార సంస్థ తరఫున మేము వారిని హృదయపూర్వకంగా ఆహ్వానిస్తాము.
Thank you. Yeah. So good morning all of you. Good morning. Well, there's so much of crowd, no noise. I'm not hearing. And I think now Andhra is becoming my second hometown. I've been traveling a lot to Andhra to impart training, 40 hours training for the lawyers and judicial officers also, right? And this program is organized so that, you know, you will know what is mediation about. Because we all know about the other ADR, is it not? Are we aware about this mediation? Yeah, fully? Maybe some of the trained mediators, they'll know what this mediation is about. For the rest are not aware about the other ADR processes, right? Okay, let me start with a question. What are the other ADR processes you know? And mediation. And in section 89, we also, there's another one, which is called as a judicial settlement also. But normally, we don't, that is between the judges it's been done. Judicial settlement is, right? Okay, so now do you think this mediation is something new to our India? Is it new? No. is it not? In form, the dispute was resolved, is it not? The courts were not there during that time, during the Puranic period or the Vedic period. It is only in India after the British had come, we had the court system. So prior to that, how the disputes were resolved? How? No, before that, I'm just talking, Panchayat, yeah? We had the Panchayat. Before the court system could come, British court system could come, we had the Panchayat, is it not? So what happened in Panchayat? Who were doing the Panchayat? Is it not? They said they were not fair, right? They thought, there was a lot of partiality when the verdict was given. So therefore, after the court system had come, they thought that is the best system, right? And the result, the Mahabharata would not have been there. Before the war, since piece of land also, even small piece of land I will not give, right? Therefore, says, then Lord Krishna says no. Then Lord Krishna says no. So see, people should have leave. That is how the war took place. And all. Was there any, do you know? Everywhere the conflict is and all. Was there any, do you know? Everywhere the conflict is something natural. Conflicts are in there with during the Agnavalka period, right? And there was something, is it not, in India? We had a lot of kings. During one of the, either it is Akbar or Solomon or whoever it is, there was one case which had come before the Darbar. Women are fighting for a small baby. Each one is saying, that is my kid, right? So the king, what he did is, he called one of his advisors, right? Tenali Raman, Birbal, whoever it is. And he said, okay, I will solve the problem. This is what he said. And he said, okay, get me the knife. I'll cut the baby into two halves, right? And he said, one half will be given to one mother and the other half will be given to the other woman. Then what happened? The actual mother, okay, the actual mother will say, no, okay, let the baby be with her. I want my baby to be alive. That's more important for me. And then he comes to know who the real mother is, and the baby was given to the real mother. So this is how, those days the disputes were resolved, when there were conflict, when there was something. And then after that, what happened? We had the Panchayat system, and then the court system, the British had come. Once the court system had come, we thought, all of us, what we thought, that is the best system, is it not? Why? Okay, so it will be binding. That is what Madam says. A court order is a binding order, is it not? It is executable. That is what Madam says. So therefore, for everything, people thought, let us go to the court. Okay, where they ask for evidences, where they ask for witnesses, right? Then you go, you argue, you do all this, and then you get an order, which is executable and which is binding, is it not? But what happened? But even for a small dispute, is it not? It may be a 3 feet or a 5 feet passage dispute between two neighbors. Did they sit and resolve their dispute on their own? Did they sit and resolve their dispute on their own for a 3 feet passage dispute or a 5 feet passage dispute? What did they do? They went to the lawyer, they went to the court immediately. That was the mindset of the people. They didn't want to sit and talk with each other, even if they were neighbors known for so many years. They had their ego. Is it not? That prevented them from sitting and talking. So this mediation, which we are going to talk about now, it is not only, to resolve the disputes in the courts. It is also to change the mindset of the people also. Right? Because these are the soft skills which every person should have. The mediation skills are the soft skills. Everyone should, practice these soft skills. Some will have, it will be there within them. Some, by having this training, they can acquire these skills, right? And ultimately, this training is not only for the lawyers. It should also go to the grassroots level for the students, right? Law college students and other students also, where, if there is some dispute between two groups in the college, they can sit and talk face to face, and they can amicably see that the dispute has been resolved. Is it not? Okay. Then, how did this mediation evolve in India? right? Actually, it is from the panchayat, certain ingredients or the concept was taken, and it was adopted by the US. That is what they do, is it not? The Western countries adopted certain features of the panchayat, and they gave it a name. They gave it mediation, right? And then in 1970, there was a conference called the Pound Conference, which was held in US, where in that conference, what they said was, court should not be the only system where the litigants can come and see that their disputes are getting resolved. They said we should have a kiosk. Kiosk is the what? You know, the desk, or, you know, the counters. The counters where the parties will come, and according to the nature of the dispute of their case, is it a family dispute, or is it a commercial case, or is it a criminal case? So according to the nature of the dispute, either they have to go for litigation, or they have to go for any one of the alternative dispute resolution. So this is how the pendency of cases in US was brought down, right? Then, what about UK? What about UK? In UK, what happened was, it is mandatory. Even before you go to the court, okay, you have to go for this mediation, right? And the party who fails to settle it and goes back to the court, and if he's going to lose the case in the court of law, he has to pay heavy compensation to the other party. So this is how damages, you know, they had to pay. So this is there, the pre-litigation mediation is there, where the parties mandatorily has to go for that, and then they have to go before the court. Then in India, what happened was, when, in 1948, there was a conference in Delhi with all the chief justice, with all the chief ministers, you know, with the president, with the prime minister, chief justice of India, you know, there was a big conference held. And it was decided there also that people should not only come to the court to resolve their disputes, there should also be some alternative, you know, forum where these disputes can be resolved. And that is how this Arbitration Act had come. When is the first Arbitration Act? When is the first Arbitration Act? 1940, exactly, correct. Is it not? So that was the first time there was an arbitration. Then subsequently, of course, there was a lot of amendments. We had it. But the first was in 1940. Then when did the conciliation come? Conciliation is seen even in Industrial Disputes Act of 1947. Section 4 talks about conciliation, is it not? So arbitration, conciliation is being there even before Section 89. Is it not? But did the pendency of cases come down? Was there any, you know, the courts were still, you know, burdened with so much of disputes. Is it not? Then what happened? Then Legal Services Authority had come. Act had come. That was in 1987. So after the 1987 Legal Services Authority Act, right, we had the Lok Adalat, Section 19. Is it not? Lok Adalat, to some extent, people were willing to go for Lok Adalat. Right? Why? They did not prefer arbitration. Right? They would go to for Lok Adalat. Why? Why? For settling only, for settling the issue. They thought, at least, you know, to some extent, the parties are given an opportunity to talk there in Lok Adalat. It is not only the lawyers who talk there in the Lok Adalat. The parties are given importance in the Lok Adalat. Is it not? Right? And then mostly, what cases were sent to Lok Adalat? Or, I can say it was mostly, you know, the motor vehicle MACT cases and 138 cases where only the quantum had to be decided. Is it not? Where the quantum had to be decided, it was sent to Lok Adalat. And in case if it is a family dispute or any other, you know, dispute, then what happens? Then what happens? In Lok Adalat, it doesn't get over in one single day. It is not over. It gets adjourned to family matrimonial disputes, how long it takes to get resolved? Maybe 3-4 sessions it needs, is it not? So one day they go to the Lok Adalat, they see 3 members sitting there. Then it is adjourned to next date. The next day there are 3 different members in the Lok Adalat. Because the members in the Lok Adalat, they keep changing. Every month when there is a sitting, they keep changing. Therefore, what happens every time the party goes to the Lok Adalat, they see a different set of persons, and every time they have to keep telling about the facts of the case, or they have to keep venting their emotions. All this, that's the reason mostly, that was also not much. But of course, people know about Lok Adalat now, right? As far as mediation is concerned, and we started, the first center to start this mediation was Tamil Nadu Mediation High Court, Conciliation Center. It was started in 2005 by Mr. Sriram, who is a senior counsel, right? He was the one who went abroad, who studied about the concept of mediation, and he came to Chennai Madras High Court, and he started this mediation there in 2005. And it is after that, we call him the Pitamagan of mediation. He was the one who sowed the seeds of mediation, right? And now it is spread all over, across the country, is it not? Now all over we have, throughout India, we have the mediation centers where mediation is going on, right? But what happens is, when the courts are referring the cases to mediation, now we all know about the AFCON's judgment, many of you all, right? Yeah, according to the AFCON's judgment, right, the judicial officer has to mandatorily send the case to mediation. This is what it says. After, the pleadings are completed, before framing of issues or after the framing of issues, he just has to send it to the mediation, right? And then, though the case has been sent to mediation, but still, in Tamil Nadu, we have around 40% of the cases as non-starters in mediation. They are non-starters. Why? Non-starters in the sense, mediation doesn't start at all because the parties are not there before the mediation center. Then how will the mediator commence with the mediation? Okay, what do you think the reason is? Why? Because they don't know about mediation, right? They're not aware about the mediation concept? Okay. The litigants will not be aware about the mediation concept, yes. But what about the lawyers? We are the one, we have to tell them about, yes, that's the reason this program has been organized today, right? Is it not? Okay, to know, the lawyers should know about mediation. What is mediation? Right? It is just unique when compared to the other ADR processes. Right? So unless the lawyers know what are the benefits, what are the advantages in taking the case to the mediation, only then they are going to advise their clients to go for mediation and also help them in the mediation so that the settlement can be arrived between the parties amicably. Right? Yeah, well, we'll talk about it, sir. Yeah, we'll talk about it. There's one session in the afternoon where we'll be talking about the role of players. All the judges have been trained now on mediation. Right? All of them have been trained. Yes, sir, we'll talk about it. The role of lawyers. I just wanted to say it, why, the reasons for non-starters are. Okay? So this is how the mediation evolved in India. Right? So Section 89 was there. That came in when Section 89 was introduced in the CPC. When was it? When was it? In 1999. In 1999, Section 89 was introduced, is it not? Then it was implemented in the year, or it was notified in the year 2002. Okay? Now we are in 2025. Right? So how many years have gone? Nearly 23 years. But still, people are not aware about the mediation. Nobody, lawyers especially, we are not aware about this mediation concept which is there in Section 89. Section 89 talks about these 5 ADR, apart from litigation. The reason why Section 89 could not be implemented is because of the wordings in Section 89. If you go home and see in the net or Google or take your civil procedure code and see Section 89, 1, it does say what a conciliator has to do in Section 73. The same thing the judicial officer has to do all this before sending the case to ADR. Is it possible? You know what it says? If the court finds that there is an element of settlement, okay, then the court has to frame the terms of settlement, give it to the parties for them to observe, and then reframe the terms of settlement, and then you send it to ADR. To do all this, what is the time needed by a judicial officer to, practically to implement Section 89? What is the time a judicial officer needs? Apart from the trial work, apart from the calling, trial, arguments, orders. After all this in the evening, the judicial officer has to call the parties, discuss with them, right? Frame the terms of settlement. The judicial officer has to do this. Then he has to give it to the parties, he or she. Then after that, it has to be referred to ADR. What is the need to refer it to ADR after doing all this? The court might as well as pass an order under Order 23, Rule 3. There was no need at all. Right? That was one reason why Section 89 could not be implemented, and it had become redundant also, because of the wordings in Section 9. This is where the Salem Bar Association versus Union of India, there are two cases, 1 and 2, wherein the Supreme Court had diluted Section 89. Okay? Salem Bar Association versus Union of India. This was a case which came from the Tamil Nadu, one of the district, and it went up to the Supreme Court. And the Supreme Court said, okay, now the practical difficulty is in implementing Section 89 as it is. That's the reason the judicial officers are not able to, send the cases to the court. We dilute that Section 89(1). They said, okay, you just write 2 lines. After the pleadings are over, after the issues are framed or before, just 2 lines. It's a partition suit. It is a partnership dispute, right? Therefore, I'm sending this case to mediation or Lok Adalat or whatever it is. After this again, there is Afcons Infrastructure Private Limited that is reported in 2010, 8 ACC, page 24. That was a case where again Section 89 was dealt by the Supreme Court. In that, they talk about, what is the stage of referral, when the case has to be referred for mediation. What is the stage, right? And then, what are the cases suitable for mediation? What are the cases not suitable for mediation, fit and unfit cases? So, in that, they say almost 99% of the cases can be referred for mediation. Almost 99%. Contracts, consumer cases, labor cases, family disputes, partition suits. The list is not exhaustive, but the thing is, this is what they say. Everything can be referred for mediation, except the non-compoundable criminal cases alone. They are not suitable. And of course, if there is a public interest litigation which is filed, PIL, or there is an election case, representative suits, right, where minors, deities, cases are involved, those cases cannot be sent. And sometimes they say even the probate and letters of administration also. These are some of the cases which the Supreme Court says it cannot be sent. But however, it says it is not, this is not an exhaustive list, and there is no hard and fast rule. If the parties are willing to settle a probate, okay, where all the siblings, they filed a thing, OP, for, there we call it as OP. Once it becomes, it is contested, we call it as a TOS, testamentary original suit it is called as. They say even that cases can be referred for mediation if the parties are willing. That's it. Now, according to the Afcon's judgment, it is mandatory for the judicial officer to refer the case, right? And then it comes for mediation. When it comes for mediation, then it is for the mediator to ensure that the parties are present and see that the mediation process is completed, right? Okay, so this is about something I wanted to talk about the overview of mediation, right? Then I'm going to talk about the different ADR. What are the advantages and disadvantages in each ADR, right? Okay, I think all of you all can tell me, right? In litigation, what happens in litigation? Litigation is an adversarial process, is it not? It is an adversarial process. What is adversarial process when I say it is litigation? Sir? There is a plaint, there is a written statement, then there is evidences, then you have the documents, the witnesses, arguments. So that we called as an adversarial process, right? Arbitration is also an adversarial process, is it not? It is quasi-judicial. Arbitration is quasi-judicial. Yes, sir. What? Okay. Yes, I understood your case, sir. Shall I answer it?
Yes, yes.
Yes, I'll give you the answer. So his question is, okay, mediation, you said mandatorily it has to be sent, right? As far as arbitration is concerned, can you send the parties mandatorily to the arbitration? Is it
yes.
not?
Yes.
Okay. Under the Arbitration and Conciliation Act, right?
Yes.
Okay. If sir is filing a suit in the court, okay?
Yes, yes.
And the defendant comes into the picture and he says, there is a contract between him and me, the plaintiff and the defendant.
Yes.
Sit down, sir. Sit down, sir. If I have not given you answer, then you can ask me again. Okay, there is a contract between the plaintiff and the defendant in which there is an arbitration clause. Right? That is what the defendant will come and file Section 8 application before the court, saying that there is an arbitration clause. Then the other side will file a counter and the judge has to decide whether there is an arbitration clause, and then accordingly, if there is an arbitration clause, a valid arbitration clause, it will be sent for arbitration. Right? The AFCON's judgment deals with this. Exactly. That is what the AFCON judgment deals. That is a case which came from the state of Kerala. Okay? One side, it was the Cochin Port Trust, which had given a contract to AFCON's Infrastructure Private Limited, right? To construct these roads, bridges, and highways and all. They had given a big contract to AFCON's Infrastructure Private Limited. In that agreement, there is an arbitration clause between Cochin Port Trust and AFCON's infrastructure agreement. There is an arbitration clause. Subsequently, AFCON's infrastructure enters into a subcontract. They enter into a subcontract with Cherry and Varghese, a company called Cherry and Varghese. That subcontract agreement does not have a arbitration clause. So Cherry and Varghese was the person who had come to the court saying that AFCON's infrastructure owes me 2 crores and odd. Right? And when the suit was filed, AFCON's infrastructure, one of the defendants, filed an application under Section 8 saying that there is no arbitration clause, therefore this cannot be sent for arbitration. However, the trial court had allowed that Section 89 memo which was filed by the plaintiff, saying that it has to be referred for arbitration. That was taken on revision to the High Court. The High Court also confirmed the trial court's order, saying that under Section 89, the trial judge has the power to send the case, okay, either arbitration or conciliation or mediation or lok adalat without the consent of the parties, it cannot be referred. Without the consent of the parties, it cannot be referred. Right? But lok adalat and mediation, the court can, if the court comes to the conclusion, it can be sent, then the court will be sending it. Right? So in litigation, we call it as an adversarial process. And arbitration also, it is the same thing. But whereas in mediation and lok adalat, it is not an adversarial process. Is it not? The parties come and talk, discuss, and they do it. Right? Then what are the other differences between litigation and other ADR? What are the other differences? What are the other differences? Here the judge decides in the court. Who decides in the court? There's a judicial officer who's going to decide the case. Right? And the order may be in favor of only one person. Is it not? In arbitration also it's the same thing. Right? Yeah, mediation is something completely different. Right? That is what we want to bring it to your notice. Mediation, okay, mediator helps the party, facilitates the party to arrive at an amicable settlement. The mediator is only a facilitator, okay, who assists the parties to arrive at a solution. This is very important. Unless you're going to tell your litigants, okay, right? You're the decision-making authority. You're the decision-making authority. The mediator is only going to facilitate the process to see that there is an amicable settlement between both of you. Unless the lawyers are aware about this, how will they help their clients to come for mediation? Is it not? Right? Okay, then, apart from all this, mediation is fully private. Unlike the litigation or arbitration, okay, litigation takes place in the open court, is it not? Right? The parties come, they sit there in the court hall, right? Okay, when they come only when the trial takes place. They are not present throughout the litigation. When the trial comes, they have to sit in the court from morning till evening, right? Then they'll be subjected to cross-examination, right? If the party cries, what the judicial officer will say? If the party is weeping with the emotions, the court is going to allow her to cry? Huh? What will the judge say? Huh? Is it not? Okay, don't cry here. This is not a place for you to cry. Okay, Mr. Counsel so-and-so will be cross-examining you. You just have to say yes or no. This is what happens in litigation, in the court. What happens in arbitration? Arbitration also, it is almost the same, is it not? But in mediation, right, it is private. It takes place within the four walls of a room. The entire, the mediation. Whether it is 60 days or 90 days, whatever it is all private. When it is private, it is also confidential. It is also confidential. In Lok Adalat, where does the Lok Adalat take place? Open space. So I have seen where, the bank on one side and the person who's taken the loan on the other side, they come and, sit, and all the other, parties also who are sitting at the back will observe what is happening. So whatever tactics this party is adopting, to repay the loan. The same thing, the party who's coming next, they'll say, give me 6 installments, give me, 10 installments, so that I can settle the loan with the bank. This is what happens in Lok Adalat also. See, I'm not saying here this is inferior or this is superior. I'm not on that. I'm only trying to say certain cases are suitable for Lok Adalat. Because I've sat as a Lok Adalat member for so many years. It is beneficial. But what is the unique concept of mediation? That is what we are trying to understand. Both parties have win-win. Exactly. Where in mediation, is it not? Yeah, exactly. Both the parties, have a win-win situation. In court, it is only one party who can get an order. The agreed party will go on an appeal. Even if it is for a 3-feet passage or a 5-feet passage, they can go up to the Supreme Court. For 15, 20 years, they can spend their time and money. Right? They can leave the litigation for the next generation also if they want. Right? That is what happens in court, right? But in mediation, right, the parties decide what they want. We say it is voluntary. That is called as, it's a voluntary process. Though the court is sending it mandatorily, once it comes to mediation, it is for the party to decide whether they want to go on for a settlement or not. Before signing the agreement, any number of offers, any number of suggestions, any number of proposals can be given by each of the party before signing the agreement. But once the agreement is signed, and it is also voluntary till they sign the agreement, which means they can withdraw from the process at any time. There is no compulsion at all. That they have to attend through the entire mediation process. But once the agreement is signed, it is binding. It is final. It is final. It is binding. They cannot go back to the court and say, no, to the judge, like, I signed, but now I'm not willing to comply. They cannot do that. There is a Supreme Court judgment on that, which, because one of the party in mediation, after signing the agreement, right, and they have said, like, I don't want to go with the agreement, no, I want to withdraw from it. So the Supreme Court has said, you cannot make a mockery of all this. You can't go spend hours together in mediation, then you sign an agreement, and then after that you say, like, I don't want to go with the agreement. That agreement can be set aside only on certain grounds. Right? Like how under Order 23, Rule 3, the compromise order can be set aside. The same grounds are available to set aside a Lok Adalat award or a mediation award also. But fraud, impersonation, or fabricated documents or whatever it is. Right? Then, what are the other things, the differences between the litigation and thing? Yeah, we saw this is private, this is voluntary, this is confidential. The order is imposed on the party. You have to do this. True, everything is done only by the parties. Right? The mediator talks very little. Right? It is left to the parties to say what they want. And I normally say to the parties when they come for mediation, I say, this is an opportunity which the court has granted you to write your own judgment. Is it not? You're empowering the parties to write their own agreement, which is their own judgment. Where this opportunity the parties will get to decide what they want. Right? So this one word by the mediator in the opening statement saying that the court has given an opportunity for you to, yes, to decide what you want. You enter into an agreement, that becomes a final, that becomes a decree. It's your own judgment for your cause. So they really feel very happy about it because they are deciding what they want, is it not? Right? Okay, then, yeah, it is about the time and cost, as sir said, is it not? So what amount of time they spent in court, right? In mediation, we have a time limit of 60 to 90 days, right? Now the act, how many of you are aware about the Mediation Act of 2023? It has come, right? But it is yet to be implemented, notified. Some of the sections are yet to be implemented. Once the act comes into force fully, then you have a time of 120 days. 120 days, right? 120 days you have time to complete your mediation. That is more than enough. Yeah, is it not? Now it has increased from 60, 90, it has come to 120 days after the act has been notified, right? And it is also convenient. I'll come to that, okay? I'll come to that. See, I was talking about it is convenient. Mediation is a convenient process. What is convenience? It is very convenient for parties. Flexible. Yeah. I can fix the mediation in the evening at 4:30 when the parties can come. I don't ask the parties to come early morning and sit in the court the whole day like how the court asks the parties to sit. I don't make them sit like that for the whole day. Right? So I tell them, when is your convenient time? And I will also see that it is convenient to me also. And accordingly, the time has been fixed. 4:30 or 5:30, or maybe if you want to have it 1:30 in the afternoon. Right? So it's a very flexible process. Convenient it is. There is no hard and fast rule that you have to do on such and such a date. Nothing like that. Right? Have the first session, then you adjourn it, after maybe 10 days or 1 week or whatever it is. Then you have the next session. And then you do the mediation. Right? Sir? Yeah, exactly. That is what it is. When you fix your mediation in the evening, as sir rightly said, that lawyers are also available there to come with their parties. Is it not? Right? Practicing lawyers. Yeah, otherwise if you're going to fix your mediation in the morning, the lawyer will not be available and the lawyer will tell the party, don't go for mediation. That's it. Where can you start your mediation? So at least till the lawyer and the party gets the trust on the mediator. That is very important. Okay, you have to build the trust. The mediator has to build the trust, build the confidence in the parties, which is very important. Unless you do, till you do that, okay, the lawyer will be there. Once he gets the trust and confidence, he gains, then he'll say, madam, you take care of the parties. I'm going to go to the court. I have some arguments. They also say they just leave the parties in our hands. Right? That doesn't mean we can, get whatever we want again, right? The thing is, again, it is only to tell you, it is very convenient and it's a flexible process. Yeah, exactly. That is one thing. That is one thing. No. Even after Section 89 had come, okay, even after when Section 89, sir, 1 second, sir. Section 89, right? It came in 1999, 2002. Why the pendency did not reduce, why people did not go to ADRS? Because the lawyers they did not think it is alternative dispute resolution. They thought it is an alarming drop in revenue for them. Is it not? That's the reason we went on a strike. They thought it's a drop in revenue. Yeah, that is it. That is also there. And one thing from the lawyer's point of view, that's it. So lawyers, naturally, Like, that's a livelihood, is it not, for the lawyers, right? So they thought, if I'm going to take this case to the ADR, right, and if the case is settled, the party will say, what did you do, sir? What did you do, madam, in this? Huh? The member settled, the Lok Adalat member settled the case, the mediator settled the case. Why should I give the fees? Naturally, lawyers will be worried, is it not? But in mediation, okay, I always, tell the lawyers, in front of the parties, I'll tell them, you've done a wonderful job for your parties. Excellent job. Wherein you did not make your parties to, be in the court for so many years. You've given them the solution, right? So I'll tell them, your lawyer is entitled for something more than what you have already given or promised. That is what they really feel happy about it. I'll normally tell, this is what excellent advocates we have for the parties. And they definitely you have to owe them some more fees for it. Is it not? Those days have gone when with the one case, advocates, did marriages for their children, constructed a house, all that is gone now, right? Today, if I finish a case, I'll be getting more fees than what I have to get it. When I went to Thrissur for a training way back somewhere in 2011 or something, on the last day of the training, we had the live cases pending in the court to be sent to the participants who had been trained, advocates, as mediators. The live cases were sent to them so that they can really, see it and do it, and we were there to, correct them also. So it was sent to them on the last day, and one of the participant lawyer, he had his case pending in the court, one partition suit or something. So he had also referred that case for mediation. Right? When it was sent to, it was given to some other, because he can't sit and do his own case, right? So it was given to some other lawyer, mediator who had been trained. And then that mediation got over, sir. It ended in a success. The parties were able to arrive at a solution within a span of 2 to 3 hours. The suit which was pending in the court for 5 years, it was a partition suit of the Muslim family. So, it is really complicated also. So, that matter got settled in the mediation within 2 to 3 hours. Okay? Then after that, we all came back to Chennai. Me and another senior trainer was with me. We came back to Chennai. That advocate, mediator, who had referred this case for mediation, he called up and he said, thank you so much, madam. Okay, my client is so happy. My client is so satisfied that the case got over within 2 to 3 hours. And you know what he said? He did not complete that. He said, now this client has got me 3 more clients. Just imagine. The next day he's calling up and he told me that I have got 3 more clients. Do we advertise our lawyers? Do we advertise anywhere? We put in paper saying that we are good lawyers? No. How do we get cases? By word of mouth. By word of mouth. Is it not? So if you're able to, resolve your clients, your party's dispute at the earliest, you're going to get cases. Right? That is what the clients are looking for now. Instead of spending all their time in the court. Is it not? Yeah. Okay. Then what else in ADR? What are the other differences you know? So we have spoken about it's a private, it's confidential, it's voluntary. Right? Yeah. That is when we talk about what happens in mediation probably. When we talk about the stages, we'll go into all that. Right? I am on this. Okay. Can you tell me why a partition suit should be referred to mediation and not to Lok Adalat? Anybody? Why? Why a partition suit or a family dispute is more, the parties will be benefited if it has been sent for mediation and not Lok Adalat or any other forum. Why? Yeah, right. Yeah. Exactly. That is what it is. Mediator, it is the same mediator for the entire case, is it not? Right? One person, sir, is appointed as a mediator, the case has been referred to him, he is the mediator till the mediation is over. Whether it is settled or not settled, unsettled. But in Lok Adalat, as I said earlier, the parties every time they have to go sit before them and tell them what is the facts of the case. Then after that it is adjourned. Then they go for the next time. The same thing they have to repeat. That's the reason, you know, sometimes all these relationship involved disputes are better suitable for mediation than Lok Adalat. So as lawyers, when you want to refer a case, depending on the nature of the dispute, in case if you think it is a partition suit or a partnership disputes or anything else, you know, where the parties would like to, you know, maintain their relationship. Is it not? Such cases, you can always tell the judicial officer to be referred for mediation. Is it not? Right, that's it. Then anything else? Yeah, then what else? What are the other differences in thing? Any other differences? Okay, we can also talk about, you know, what are the benefits of a mediation. One is you can get the court fee refunded. Is it not?
If the mediation is not completed in 1 or 2 or 3 or 4 sittings, then they can go for private mediation too. Am I right?
No, I think what you're telling is, you're telling again about the stages. You're talking about the stages, I think. Is it not? Okay, that will come a little later.
Okay.
That will come a little later, is it not? Okay, now this mediation is entirely, you know, a new concept where we have to understand what is mediation. Okay? What are the important concepts are there in mediation? That is more important. So what is the mediator role here, you think, in mediation? Mediator is going to pass any orders? Okay, he will not be a party to the agreement also. He cannot sign the agreement. Only the parties and the councils will sign the mediation agreement. Right? Okay, the court fee, in case if they have paid a high court fee to the, at the time of filing the case, true, if it is a partition suit, exactly, if it is a partition suit, right. So that is, that's what it is. So court fee is not there, right. Then what are the other things? Okay, the mediator, when the mediator explains the role, the mediator has to explain, you know, what is the role of the mediator before starting the mediation. We'll come to that. We'll be talking about in the stages. I just want to complete these differences in ADR, right? What are the other things you think it's most important which we have? See, in the court of law, what does the judge looks at for passing an order? What the judge looks at for passing an order in a court of law? Evidence. What does the law says? Okay, what does the act says? It is within the framework of law. The judge has to pass an order. Arbitration also it's the same thing. Arbitration and Conciliation Act binds, is it not? They have to go only according to the act. Lok Adalat, you have the Legal Services Authority Act. For mediation, okay.
It's a flexible.
In mediation, there is no any provision or any law or something like that which you have to be bothered about. That is what I'm trying to say.
It's a flexible one.
It is a flexible process and there is no, you know, such laws or something which is governing mediation. That is there, right? So therefore, the parties can also talk about not only what they are legally entitled to, they can talk about their interests and needs also. They can talk about their interest and needs in mediation, right? Okay. I think these are the differences as far as ADR is concerned. Any other questions so far on this? Counseling. Counseling?
What is the difference between
counseling?
Counseling and mediation.
And mediation. Okay, good. That's an excellent question. Sit down, sir. See, in Family Courts Act, they have to go for counseling, is it not? It is mandatory, right? What does the counselor do in counseling? What does the counselor do? What does the counselor do? They give advice, they give suggestions, okay? They say in case if it is a matrimonial dispute, the counselor will say, don't divorce. They'll say the wife, okay, they will not understand why she wants a divorce. They don't go into that aspect of it in counseling. Why, this lady has come here for a divorce. Without that, they'll say, no, you should not go for a divorce and all. Okay, right? And they will start advising with the party. They'll start giving suggestions. Right? They'll say, okay, in the interest of the welfare of the child, you have 2 kids. 2 children are there. Why do you want to divorce? But here that party will be undergoing so much of, cruelty and torture. That's the reason. Otherwise she would have lived. Why she has to come to the court? This is the counselor's job. Right? In mediation, we do not do anything like that. There is no advice from the mediator. The mediator does not advise the parties. Right? We don't do any counseling there. Okay? We don't give any suggestions there in mediation. Right? In the private session, we act like a devil's advocate sometimes. In the private session, we act like a devil's advocate asking some hypothetical questions. It is only by way of questioning we try to bring out what the party exactly wants. I'll just tell you a small illustration where the brother and sister had filed a suit for partition. Okay? The sister had filed a suit for partition claiming 50% share in the brother's property. Okay? When it came for mediation, the sister, okay, after that joint session, the sister said, see, he is my brother, right? My father died intestate. There was no will, no settlement, no nothing. Now there's one property in which I'm claiming 50% share in my brother's property. This is what is known as position. This is called as a position in mediation. We have to learn these terms. Position is what the stand they take, or the prayer, or the relief they have claimed in the court. Okay? That is a position. I want 50% share from my brother is the position. Okay? Now, other's face also. Then he also said that you're not my sister. This is the words he has used. You're not my sister. You were not born to my father. Right? And in the legal heirship certificate which he had got, he did not include her name. He had omitted to include her name in the legal heirship certificate. So, the reason for her filing a share is she wanted a share in the property, or because of this brother using such words in the when she had gone. What is the root cause for the problem? What is the root cause for the problem to come to the court? It is the abusive words which she had used, is it not? That is the reason for her to coming to the court. Okay, in a court of law, the court is going to give only saying that, yes, you have 50% share in the property, is it not? That is the only order the court can pass. Right? What about her other hurt feelings? For her emotions? Okay, this is what my brother has said about me. Is she going to get any decree in the court of law? No. Maybe the court will direct her name has to be included in the legal heirship certificate. But she said here in the private session, I want an apology from my brother. For whatever words he had uttered against me, okay, this property and all is not very important. Okay, I need an apology. This is what she said in the private session. So you come to know what is the real need an apology. And you talk with the brother in the private session, need an apology. And you talk with the brother in the private session. What do you have to say now? In mediation. We've been talking about it all along, is it not? From mediation. We've been talking about it all along, is it not? From that. Okay, definitely the parties have to have an amicable settlement. That is the end, is it not? Okay. Yes, a mediator is a neutral third party. Mediator is a neutral third party. Why I say I am neutral? I should not have any conflict of interest, or I should not have any interest in the outcome of the solution. You are a neutral person. That is very important. One of the important quality for the mediator, being very neutral and impartial. Yeah, that will come. That is some of the other qualities also, right? Okay, so mediation you can define as, okay, mediation is a voluntary and confidential process, right, in which a neutral third person, the mediator, assesses the parties in arriving at a settlement. This is how you define mediation, right? So voluntariness has come, confidentiality has come, you're a neutral person has come, right? And facilitating the parties to arrive at an amicable settlement. This is how you define mediation, right? So what are the 4 stages we're going to see in the mediation? What are the 4? See, now this mediation, unlike other ADR forum, it has got a structure. It has got a structure. So this is how the mediation has to be done. It is not like counseling, just call the parties, talk with them and you do this, why don't you do this, why don't you settle it? It is not that way. It has got a structure. Though it has a structure, still it is a very flexible process. Still it is a very flexible process. So the first stage is called as the introduction and the opening statement. It's called as the introduction and the opening statement. Do we have such introduction of the counselor or the judge or the arbitrator in any of the ADR where the mediator introduces herself or himself? Do you have any such introduction formality in any of the ADR? Do we have? Counseling, the counselor goes and says, the parties, I'm so-and-so, what is your name? Do the counselor ask for any such thing? You would have gone? No? Is there any introduction in any of the ADR? Simple, my question is. No, is it not? But in mediation, there is something. The first stage is called the introduction and the opening statement. Okay, like how you welcome guests at home. The same way you have to receive the parties and greet the parties. Randi. Okay, kuchandi. Okay, this is what you say when you have some guest. The same way you have to welcome the parties to the mediation room. So what are you doing to the parties there? You're giving them respect. Right? So they really feel happy about it. Here is one place where, they welcome me, they greet me, they're giving me, places to sit. You offer them seats to sit in mediation, right? Yeah, so the first thing is, the first impression is the best impression. You greet and welcome the parties to the mediation room, right? And then what is called is once they've come and sat in the room, it is for the mediator to take control of the room. Okay, control of the room, so you sit here. Madam, you sit here. So, the outcome is with the parties. The outcome or the solution is with the parties, but how to conduct this mediation is with the mediator. How to go about this process is with the mediator. Right? Yeah. So, though we say the outcome or the solution is with the parties, how to conduct this mediation is with the mediator. If you're not able to control the parties there, sometimes they are seeing for the first time after 10 years or 15 years. There's so much of animosity, hatred, especially in matrimonial disputes, where the first time the parties are coming and seeing each other in mediation. What happens then? What happens? They'll be, very aggressive, and there'll be an altercation, and you sitting there as a mediator, you will also get 2 slaps on your face. This is what happens sometimes. If you don't have a control over the process, how to do the mediation, okay, we have cops sitting outside the family court mediation center. We do have. Because sometimes it just goes, basak they become, and then, they start, and sometimes they're so bad, so violent they are. And you won't know how to control them. So initially itself, a mediator has to gauge, how the parties are, whether it is safe to make them to sit next to next, or it is for you to decide they are going to sit in the opposite, right? And make the counsel sit in between. Let the counsel get something if they want, but not the mediator, is it not? And normally what we say is, a round table is preferable to conduct the mediation. Okay? Why a round table? why a mediation, to conduct a mediation, we say a round table is preferable. Yes, you all are trained mediators, you all are giving me the answers. Yes, okay, it is to have a good eye contact. It's very important. Okay, even if I'm standing here, I want to traverse. I want to, have a eye contact with it. Of course, it's very difficult. If they're sitting, far behind, I can't have an eye contact, but still I can see what they're up to. Is it not? So the eye contact with the parties is very important. So we say a round table is always preferable. Not only that, okay, suppose a company CEO comes on one side. Okay, and here there's a worker. Here there is a worker. Okay, all of them are treated equally in mediation. Yes, sir, we'll talk about it later, sir. Okay, we'll talk about all that. See, initially when we started, so one second, initially when we started this mediation in 2005, where we did a mediation in Madras High Court? It was in the court halls. We did the mediation in the court halls. After evening, in the evening 4:45, after the judge rises, we used to go and, sit there. It will be an horseshoe table. And there we sit and did the mediation. And that OA will be waiting for us. For him, he has to go. We can't conduct and do the mediation for 2 hours, 3 hours and all. 4:45, maybe till 5:30, he'll be okay. 5:45, he'll come and see inside what we are doing. Right? And so that's how it started. See, everything, you don't get everything immediately. We have to wait for the period, is it not? Now, of course, after how many years? Nearly 20 years, now we have a beautiful center in the Madras High Court. So it takes time, is it not? Yeah, we have to wait for that. So the round table is always preferable. Want to see that there is a balancing. There should not be any imbalancing of the parties, right? All should be, all are placed in the same pedestal. There is nothing like, the mediator sits somewhere in a higher pedestal and the parties, right? Only then, okay, where say everything. Right? When I say neutral, I'm supposed to ensure that I have a, eye contact with both the parties. When I'm doing the opening statement, I have to say few things looking at one party and the rest few things looking at the other party, which is very important. Otherwise, or you're biased. Party will not come for mediation the next day. Is it not? Right? In colleges, what happens in colleges? Just refresh, right? There's a lecturer who's just looking at one side here and just ignoring the other side. So what will happen to this part of the group? What will happen? They'll be in their own world, right? Thinking about something, okay, thinking what I'm going to do this evening or something like that. Because I'm not looking at everybody here. So they feel that they've been ignored, right? So they won't have any interest in talking with me. Even if I'm going to ask questions, nobody is going to answer me because I've totally avoided one part of the group. In mediation, right, you have to ensure that you have a eye contact with both the parties while doing the opening statement. So you explain your role as a mediator. What is your role? Right? And you say why the court has sent this case to. Then you talk about the voluntariness. Voluntariness is at any time you can withdraw the process. If you're thinking it is not going in the, take a chance and see if I to sit and talk with my opposition, right? Because at an online mediation, where no recording of any of the proceedings after being shared in the joint session. So when they share that confidential information, you're not supposed to share that information to the other party without this party's consent. That is confidentiality. One is, you will not be called as a witness, you will not disclose to anybody. The second is, in the private session, whatever is being said, you will not disclose to the other party without the consent, right? Then you talk about the benefits of mediation in the opening statement. Voluntariness, confidentiality, about your role as a mediator, then what are the benefits? Maybe you can say like, it is final. Once there is an agreement, it becomes final, it is binding, so there is no appeal, right? Nobody can challenge this award, that is also there. You also save your time. And in case if there is a refund of court fee also, in case sometimes they would have paid a higher court fee, right? They would have paid, the court fee would have been paid in lakhs in some cases. And you say, in case if there is a settlement, you will be entitled for the refund of the court fee also. All these little informations can be given according to what the case is. Then finally the ground rules, right? What is that ground rule? Any idea? I think they will be able to tell me. The ground rules is, see, one person to speak at a time. One person to speak at a time. I'll be giving equal opportunity to both the parties, but while talking here in the joint session, it is going to be one person to speak at a time. There is no interference by the other party. If you're not going to say all this initially, when you start the mediation, if you don't say this, then what will happen? No, what happens? See, if you don't say, it is only one person to speak at a time, one party. After he completes, sir, I will be asking you, you omit to say this because of something. You don't remember to say this ground rule. Then what happens during the mediation process? Huh? There will be, argument, counter-argument, allegations. It will go on. Interference will be there repeatedly. You will not be able to conduct the mediation process at all. Because here's one party saying, this is what happens. As lawyers, what we do in court while we are arguing? What we do? The plaintiff stands, counsel stands and argue. Immediately what we do once he starts arguing? We get up so that the judge will lose their, to divert the judge, we do all these tactics. Is it not? We see that, we get up immediately and we'll say something else. This is what he did. That is the reason I've come to the court. And poor judges, what will they do? They won't know, how to hear both of you. Then they'll say, you please sit. Is it not? So in mediation, initially, it is only one person who's going to talk. The other person should not interfere at all. You will be given the time and opportunity. That is the time you have to speak. And no using any harsh words, right? We use polite words as far as possible, right? So this is what happens in the first stage, the introduction and the opening statement. Then the second stage is the joint session, right? Joint session, what do you understand when I say it's a joint session? Okay, right. So both the parties will start with their narrating the facts of their case. That is what happens. So when you say you're a neutral person, how will you start it? How will you start that? Yeah, that is summarizing subsequently. So when you start with the joint session, you ask, so who would like to speak first? Your neutrality, not only at the beginning, till the end they sign the agreement, you should be neutral. The way you speak, the way you talk, the way you look, because the parties are observing you. Any small facial expression or changes in your face also, this party will know that I'm not neutral. Is it not? So I have to be neutral. So I'll ask who would like to speak first. Then if both of them are silent, nobody says who wants to talk, right? Then I'll ask who's the plaintiff then. The plaintiff can commence. So you talk. You tell me what is it. You narrate your facts, right? And one thing is it necessary for the mediators to go through the pleadings before starting with the mediation or before starting with the joint session? Do you think is it necessary to go through the pleadings, the plaint or the written statement which the court sends with regard to the dispute? Do you have to go through? Okay, so I'll take majority of you all say that, we have to go through the pleadings, that's it? Can I take it that way? Majority of you all say that we have to go through the pleadings to know what the facts of the case are? That is what you all are saying? Yeah? Can I take it that way? The answer is no. No, we don't go through any of the pleadings, the plaint or the written statement or the petition. No, we are only drafting all that, no. Okay, I'll just tell you all one thing. A client comes to an advocate's office, right? A lady client comes to an advocate's office and she asks, tells the advocate, kindly you send a notice to my husband. He's not taking care of me. He's not providing the maintenance. This is what the client comes and tells to the advocate. So the advocate says, okay, madam, I'll have the legal notice ready. Okay, you go back and come after some time to me. So after a week when the client comes, okay, the lawyer has drafted the legal notice. He wanted the client to go through the notice, right? after seeing the notice, okay, this client started crying, weeping. So the advocate was really surprised. The advocate asked, why are you crying? Why are you weeping like this? What is the problem? When you came the first time also, you did not cry. Now after seeing the notice, why are you crying? You know what was the reply the client gave? Yeah? It is only after going through your notice, sir, I realized how much of torture I've undergone by my husband. This is what she said. Right? So we are very good in drafting. Right? We know how it has to be drafted, because I am not saying anything wrong. I am only saying that is what the law requires. Therefore, according to, to see that the framework of, the thing is, law is being satisfied, when you go to the court, this is what they want. If it is a petition on cruelty, these are the things you have to have in that divorce petition. Therefore, that is the reason we are doing it. But in mediation, if I'm going to read all this, whatever is there in the divorce petition or in the plaint, what do? I come to a preconceived conclusion, a notion. Okay, this is what the party wants. Why should I then, listen to the party? I don't need to listen to the party at all. Right? I can just go through it and then do it. So in order to know what are the, what is the confidential information, for that you have to listen only from the parties. No need of reading the pleadings at all by the mediator. We are not there to pass any orders. Then why should we go through all the pleadings? Is it not? Right. Okay. So then, we'll just go through the cause title of the plaint. Why? To know who are the parties there. Whether party X, Y, Z are there, to ensure that the parties are there. And then the next thing is, in case if it is a company, is one of the party there. Whether the company's representative who has come there has got the authorization letter to participate in the mediation process. Okay. Right. Okay, so this is the, so what happens, as madam said, after you complete, with one party, the party is narrated, you summarize it. That's very important. Why are we doing all this? Why do you summarize? Party A has completed whatever he has to say. Now I have to summarize to party A, whatever he informed. Why I am doing it? Yes, to make the parties to understand, I have listened. Is it not? I have listened to whatever you said. Not only the facts, the feelings, emotions, everything has to be captured while you're doing it. Is it not? That's the reason you summarize it, right? And then you repeat the same thing with the other party also. And again, you summarize it. This is the joint session. At the end of the joint session, the mediator should be able to identify what the issues are. What are the issues involved in this case? According to party A, what are your issues? Party B, what are the issues? Otherwise, every time the parties come, they'll keep talking about their facts. There will not be any progress in the mediation at all. If you're not going to identify the issues at the end of the joint session, it is not framing of issues. Don't frame the issues. Only the court will frame the issues. For the mediator here is to identify the issues alone. From party A, what are the issues? Divorce, reunion, custody, alimony, visitation rights, then my jewels, whatever it is, return of jewels, articles. These are the issues from party A and these are the issues from party B. So the joint session is over, right? The second stage of the mediation is over. The third stage is called as a private session, right? This is where we talk with the party individually. We will not have the other party or the other party's counsel. Maybe party A and his counsel can be there. But not the other party and his counsel. So you ask them to be outside, then you start with the private session. What is the purpose of the private session, you think? Why do we have to have a private session? Why? Okay. If there are any other confidential information she wants to share, okay, that can be disclosed in the private session. What are the underlying issues? What are the underlying, and to generate options, how do you think this problem can be resolved? See, the private session can be used for so many objectives to attain your goal. Not only to gather more information, and also to find out what is the confidential information, what is the underlying interest, what is the underlying issues, to generate options, to do the reality testing. This is where we need the lawyers the most actually, right, to help their parties. We ask them instead of settling here, going back to court is the better option for you. Instead of settling in mediation, do you think going back to the court is the best option or is it the worst option? Then you're making the parties to think whether settling here is good or going back to the court. This is called as the reality testing way we talk about the strength and weaknesses of the case. We don't tell them directly you have a very bad case. The mediator will not do that. The mediator only will ask questions to find out, okay, so have you thought about it? Do you think if I'm going to send it back to the court, do you have a good, option, or you're going to get a good decision in the court? That way you make the parties to think whether to settle here or to go back to the court. So these are some important questions. It's only by way of questioning, the mediator will ask the parties what exactly they need in the mediation. You don't give any suggestions, or you don't tell them you don't have a good case at all. Right? In the private session. Even then, there is a way to say things. That is what we say. There is a way. You don't act like, saying that, because I'm a lawyer, I don't say, sir, what is this? You don't have a good case at all. Can you tell your client? No, this is not the way you tell them. There is a way you just tell them, you go discuss with your client about the pros and cons, and you come back to me. Then maybe they'll have a session in their chamber. Okay, they'll have a discussion, they'll talk about it, and then they'll come and tell you whether they want to go for a settlement or not. Right? Okay. Then the last is the agreement. Right? If there is an agreement, the parties are going to what? They will decide the terms. They will decide what they want. Okay? For each, issue, they will say this is how we want the solution to be. It is on their terms, the agreement has been drafted by the councils. The councils are going to draft the agreement. Here again, the councils are needed. Right? In the mediation. It is not the mediator who does drafts the agreement. It is the councils. So they can collect their fees also, no problem. When they're doing all this, okay, so we can also say, this is how your council has helped the parties. Therefore, you owe them the fees. Right? Okay, so in case if there is no agreement, then what happens? Refer the case back to court. Okay, and I don't say mediation failed. I never write as mediation has failed. Mediation doesn't fail. Does mediation fail anywhere? Huh? Does mediation fail? Mediators, tell me. If they say mediation has failed, then the mediators have failed. It is not the mediation has failed. It is the parties who are unable to arrive at an amicable settlement. This is what I write. I don't write the mediation has failed or something like that. I'll say the parties are unable to arrive at an amicable settlement. Hence, the case has been sent back to court. That's it. Apart from that, you're not, as a mediator, is going to write what transpired in mediation. That is very important. Okay? Because it's a very confidential process. In one case, the mediator, in the minutes, he recorded everything. What the party said, what the council said, what this party said, what the other council said. He recorded everything in the minute and report. And that was sent to the court. Right? Then I think it was in the Supreme Court. Then what they said was, why this mediator has written everything? It's a confidential process. He only has to write. If there is an agreement, there is an agreement. If there is no agreement, the parties are unable to arrive at a settlement. The credit goes to the party. Whether if there is a settlement or there is no settlement, it is on the parties. You don't take any responsibility for not settling the matter. You're only there. I normally say, I'm taking the horse to the pond. I'm taking the horse, the parties to the pond to drink water. Okay, the parties say, I don't want water. What will you do as mediators? It is not in your hands. You're only a facilitator, is it not? So I just say, the parties are unable to arrive at a settlement. Hence, the case has been sent back to the court. Yes, sir, you have something, sir? Yes, to the same court. Yeah, so it will go back to the same court from wherever the case was referred. The case has been referred from the High Court, it goes back to the High Court. If the case has been sent from the family court, then it to the mediation center, it goes back to the respective courts only. The report goes. Then Yes, sir. Can you have this mic? So that everybody can hear? Yeah. Yeah. We wanted to do small skits and all, but I think, we don't have the time. We'll see in the afternoon.
A mediation, a successful mediation agreement signed by the both parties. In case of divorce, wife and husband, both parties agreed in the mediation agreement. And before the granting the decree by the concerned court, one party changed the mind to remove from the agreement, change the mind. What is the consequences in the particularly matrimonial matters? In the matrimonial matters, even they filed the 13B petition, before the decree they can change their mind. What the in case of mediation agreement, what is the technical position of the mediation agreement?
Okay. Sir's question is, the agreement is signed by both the parties. Okay? The councils have also, signed the agreement. It has been sent back to the court. And before the court, they tell the judicial officer saying that, I don't want to go with this agreement. I want to withdraw myself. Is it not, sir? That is your question. I want to withdraw. One of the parties says, I'm not agreeing to some of the terms. Okay, I want to withdraw. What do you say? No. I have explained already. I've said all this again. I think I said this. Huh? They cannot withdraw. Till the agreement is not signed, they can withdraw. I can come and tell as a party, I'm ready to pay 10 lakhs to the other party today. Tomorrow I'll come and I'll say, I will not give 10 lakhs, I will give only 5 lakhs. That offer and proposal can go on for till signing the agreement. Okay, whether to settle or not. But once it is signed, it is binding. They cannot go back on it. That is what there's a Supreme Court judgment also saying that you cannot make a mockery of the mediation. You cannot go sit and spend hours together. You sign the agreement because nobody forced you, is it not? That's the reason we say the mediator should not force the parties to enter into any agreement. In case if you had used some coercion or some influence, or you would advise them saying that you signed the agreement, then maybe then you have to face it, right? No, not that. See, it is assumed when they sign it, it is assumed it is voluntary. They've signed it on their own, right? But sometimes what happens is, yeah, okay. Yeah, okay. Yeah, I think, so sorry about it. I think lunch is ready, right? See, yeah, okay. Yeah, it's a 40-hour training program which we want to, say everything in one day, right? So it takes a lot of time.
Hello.
Yeah, thank you.
Thank you, madam. Thank you very much.
Thank you.
So we have arranged lunch in the cellar of this building. I request all the learned advocates to join for lunch. And sharp 2 p.m. we have to gather here, or else in the evening program will be delayed. So please cooperate for the early conclusion of today's program. Thank you. Thank you very much. Sir, please. Yes, there is one separate stall for the women and 2 stalls for men. Okay? There are 3 stalls, 1 stall for women, 2 stalls for men. Okay, please join, sir. On the right side of this hall, the washrooms for the men are provided, and the left side, the washroom for women are provided. Thank you. No, people don't want to leave the class. That's why Babita madam and filed one interim application.
To you.
Sir. Huh? Sir. Oh, అవునా సార్. అవునా? కూర్చోనా? Nice, nice, nice. అవునా రమ్మని. అవునా సార్? నైస్ సార్. మరి మీరు కూడా ఒక అరుణాచలం చేస్తుంది. Please you go in your room and fresh, madam. I will, in the meantime I will bring. Lunch is provided in the room, madam. సో మీరు కూడా క్లాసులు తీసుకోవాలండి, పిలుస్తాం మేము సీనియర్ అడ్వకేట్లు. సో దట్ పీపుల్, కొత్త పిల్లలు, మెనీ ఆఫ్ ద పీపుల్ విల్ గెట్ బెనిఫిటెడ్ సర్వీసెస్. చెప్తాను నేను ఏదైనా కార్యక్రమాలు ఉన్నప్పుడు ఒకసారి ఏదైనా టాపిక్ మీద కొంచెం మాట్లాడారు. పీపీ చేశారన్నారు కదా, అవునా సార్? ఇది వేరే కింద ఇచ్చేసి ఆఫీస్. సబ్స్టాన్షియల్ పార్ట్ కంప్లీటెడ్ లంచ్. సో మంచి లంచ్ అయింది కాబట్టి పోస్ట్ లంచ్ సెషన్ అంటే మనందరికీ తెలుసు ఏం జరుగుద్దో. అందుకే బ్యాక్ బెంచెస్ నుంచి కొంచెం ముందుకు రమ్మని అడుగుతున్నారు. తిలక్ వెనక్కి వెళ్ళి ముందుకు పంపించే. అందరూ రావాలి, బయట ఉన్న వాళ్ళు త్వరగా వస్తే మనము మళ్ళీ 4 గంటలకి జస్టిస్ రావు రంగనాథరావు గారు వస్తారు. ఆయనతో మళ్ళీ మనకి కార్యక్రమం ఉంది, ముగింపు కార్యక్రమం. మళ్ళీ అందరూ ఊర్లు వెళ్ళాలి కాబట్టి తొందరగా వస్తే మనం కార్యక్రమాన్ని తొందరగా ముగించుకోవచ్చు. ఇస్తామండి, సెలవు ప్రకటిస్తాం. So please come forward. బయట ఎవరైనా ఉన్నారు అడ్వకేట్స్? తొందరగా రమ్మనండి, మరి స్టార్ట్ చేద్దాం. స్టాఫ్ని చెప్పండి వాళ్ళకి.
హలో హలో గుడ్
సార్.
రెడీ సార్, స్టార్ట్.
ఓకే. నౌ ఐ రిక్వెస్ట్ శ్రీ అరుణాచలం గారు, who is a master trainer since 2006, master trainer of mediation from Tamil Nadu. And he has a rich experience of 35 years in advocacy. Now I request Arunachalam Garu to take this session. Sir, these are advocates from all over the state. 145 bar associations are here, sir.
145.
And High Court Advocate Association is also here, members from. So, and 13 DLSS. So I request you take this session, sir. Thank you.
Thank you, sir. Greatly obliged. Good afternoon. For some time we will going to see what are all actually the challenges being met by both advocates as well as the mediators. The first challenge is we have come from an adversarial setup. Madam has in the first session explained very categorically what is adversarial. So our development is right from my grandfather, my father and myself, all in the court process. What is adversarial? Adversarial is something like this, we are fighting each other. We want this, I want this. That is the thing anywhere. If you put the plaint I'll file the petition to reject the plaint. If you file the plaint, I'll file the written statement. So all the way, our thing is that I belong to Kanyakumari district, you believe it or not, our grandfathers have fought for a single banyan tree. For a single banyan tree. You know, believe it or not, up to Supreme Court. When the matter has gone to Supreme Court, the banyan tree became older and older and fell down. So that was the real thing of this adversarial nature. We know two things. One is to fight or to plead. In between, there are things. In between, there are things we may not know. So therefore, there are consensual jurisdiction also. What is consensual? See, every advocate we are meeting the issues only by wakalat. Only by wakalat. In Tamil there was a film Gauravam. At the time Sivaji Ganesan was acting. At the time when he was acting, at the last moment he was taken trial. At the time of trial, he will be cross-examination in the party. Then a particular sequence was not there originally, that was not discussed by this client. Then he'll be asking, what? Abistu, you have not told it earlier. Something like that, at the time of cross-examination. Then the whole examination will go on in a different style and went for a defeat. So the point is, the stakeholders are not being taken into account for a long time, for all these years. It was found out only in the Pound Conference in 1976. You can see Warren Burger, sir, please, sir. Display. You know Warren Burger, anybody? Justice Warren Burger. Any idea? Just display. Warren Burger. Warren Burger, see him. He is the 15th Chief Justice of American Supreme Court. We have lot more panchayat system, everything. But still, he is a Warren Burger. He is the 15th Chief Justice of American Supreme Court. Somebody asked him, what is justice is all about? Could you please explain? He said, lawyers are the healers of the human conflict. Lawyers are the healers of the human conflict. We must produce mechanisms. We must produce mechanisms that should provide acceptable results. What do you mean by this is consensual? Acceptable results. That means by both the parties. That should provide acceptable results in the shortest possible time. Not like the case of the banyan tree for 40 years. Acceptable result in the shortest possible time with least possible expense, with a minimum stress on the participants. With a minimum stress on the participant. Appa, that is what about justice is, he said. He is a man. He opened, he questioned directly the system. And in the Pound Conference, one Mr. E.S. Sander presented a paper where he said, no, absolutely not. This system of adversarial proceedings has multi-doors. You assume if this big auditorium has only one door, they emphatically denied. At the time, everybody was, at the time E.A. Sander was presenting the paper, the Pound Conference, everybody was on the edge of the seat. Wow, what a wonderful thing. He said, it has multi-doors. The justice system has multi-doors. Don't think that it is only to say you are right, you are wrong. It is not like that. It has a multi-door. Please. So that is a way this consensual jurisdiction taking into account the stakeholders. You are the stakeholders. Therefore, I must ask you, what is actually you want? What is actually you want? It is not what actually the law wants. What is actually you want? You both. When you ask you both, what you both want, then that will definitely meet the interest of the parties. That's what Madam took in the first, as a first class. We'll have to concentrate on the interest of the parties. What is our challenge? Our challenge is actually in this adversary system, our challenge is to identify the interest of the parties. Right? That is very, very important. Let us have a small demo. How we are going to identify the interest of the parties. You know, in this consensual system of mediation, we have a triangle. Let us suppose, because the board is not there, let us suppose we have a triangle. One is upper, here down, that side. Here is a substantive way of doing things. Here is a procedural way of doing things. So far and so forth, right from the beginning, right from our grandfather's day, we have only these two procedures. One is dealing with substantive law. What is substantive law, anybody? Something defines the law. What is substantive law? Substantive law is a law which is passed by the, what is called the consent of the people. That is passed by the parliament. And as if it is notified, is called substantive law. For the implementation, we have thousands of procedures and procedural laws. That is called procedural law. So far, this system knew only substantive and procedural way of doing things. Not more than that. Absolutely. But where we will go? My father beats me. What to do? I want to weep. Do we have the system? I want to raise my voice. Do we have the system? I want to plead. Do we have the system? No. So far, we have only adverse system to find this petition, that petition. Finally, our masters, honorable judges will say that according to the law, they will honorably say that this is wrong and this is right. But in between the substantive law and procedural law, in the top, there must be an emotional approach. Where is that? There must be an emotional venting. When the dead body is there, see, I must weep. I must have that ground. When the dead body is there, I must weep. I must be given the opportunity to weep. Otherwise, how can I vent my feelings? This mediation system, this consensual system gives that opportunity. Therefore, in this triangle of substantive, procedural, there is an emotional thing which has not been met at all so far. This mediation gives the opportunity. You people, please come, sit down. You say something more and more and more and more. If you want to weep, you weep. If you want to laugh, you laugh. No problem. This is the only place. Yesterday when the training was going on in Rajamundry, there was an excellent idea which came. In arbitration, nobody is welcoming you. In the litigation, nobody is welcoming you. You are being, with all smile, being welcomed only in mediation. It is a life science. Therefore, the emotional venting is possible only in consensual systems, not in any other system. The challenge is whether we are able to, we have only seen three things. One is we'll fight or we'll be sympathetic. will be fighting or will be sympathetic. We do not have any other way. We do not have any other medium way, middle path. We don't know. As Buddha thought, we don't know the other middle path. So other middle path is empathetic approach. So that is the only challenge. That's the biggest challenge. Our persons who are trained in the adversarial pattern is not knowing the fact that there are other paths, namely the empathetic path. Let us suppose all the three paths how they are going by a demonstration. See, once we learned the empathetic approach, either you have completed the 40 hours of training or not, you will be one of the best persons to approach. You can meet all your problems in house itself. You believe it or not, one of the training is an experience gained by one of our trainers. 4 days training was over. 5 days training, you know that. 40 hours training is very much necessary. But have people on the queue. I heard that in Delhi, even for giving 40 hours training by the Judicial Services Authority, lakhs and amounts are being charged in Delhi. Therefore, you are most fortunate. You are getting an opportunity to undergo, at least in the near future, the 40 hours training. Those who are not undergone, please undergo. It is a wonderful thing. It is a scientific learning everyone must know. Now, let us see how this third approach, that is empathetic approach, is being met. Let us see if we can see a small demo here. We know so far the sympathetic approach. We know, we'll weep. Sorry ma, what happened? Oh, such a big accident. Sorry, then what happened? We know. Otherwise, hey, what nonsense. What are you saying? Is it right on your part? We know this. We know these two models. So do we know the middle model? That is the empathetic approach. Let us see how does it happen. By a small demo. Here is a party in the mediation room. This party has a family problem. Now I am the mediator. I am doing a private session with the party. In mediation is the only place where a private or separate opportunity is given to the parties. Now we are in the private session. The same opportunity will have to be and will be given to the other party also. This is a fundamental principle in mediation. Mediation is a very confidential and voluntary process. Therefore, the equal opportunity must be given to both the parties. Now here is a demo. Demo, we wanted to express how the empathetical part is taken a turn and is being concerned and giving importance. Let us see. Please, ma'am. Come. You are Madam Ratnatara?
Yes.
Yes, you came yesterday. Sorry, the last joint session you attended, is it not?
Yes, sir.
Oh, okay. So, okay, ma'am. Therefore, today straight away will be... Ma, what are you doing? You have come to mediation. Weeping. We will not give you anything. Mind it. You have to say something, unless otherwise we are not able to know that. I'm telling you only. Say something. What nonsense. Amma, I'm telling you only. Say something.
Sir.
What nonsense. Ma, you see?
This is the first thing, okay? Okay. I'm just trying to control.
Not able to cope with the actor. Anyway.
Yeah, okay.
Amma. So now it's the next day. Okay. Next day. The party is weeping. So mere weeping, we can understand the pain of the party, but we are not able to. However, the mediator is so arrogant. The mediator is not able to know. See, you are here only to talk. You speak. Otherwise, you go. That is, this is the first item. It is a sort of arrogancy. This we know. In the adversarial proceedings, we know that no fight, no to fight. We'll be fighting. Yes, say or not. Something like that. But see, the next item. You're completely on the other side. A sympathetical outlook. A sympathetical outlook. These two things are very, very familiar for us. That's what I'm saying. These two things are very familiar. Either to fight or to take a sympathetic view. Two things are very familiar. Let us see the other thing. Still she is weeping. The next sitting also she is weeping. Let us see. Amma, what happened? Amma, don't weep, ma. So, this is the second approach that all we know. The second approach, all we know. Because one thing on that adversarial side or on this side, this is the two things our people know. If you want weep, then you will plead for that. Then another approach is also there. Taking into account the concern of the parties and go into it. That is the middle way. That is middle way is only taught by us in the Pound Conference. Is only taught by us in the Pound Conference. When E.A. Sander presented the paper, he said, no, this justice system has a multi-door. Let us see, let us work on all these doors. We have got every right to go by through all these words, all these doors. That is the thing. Let us see how this mediation works by a sympathetic approach. Now, this is a third session we have come. So, mediation is vent your feelings, no doubt about that. But however, you see, unless and until you say something, we may not be in a position to understand your full problems and something behind your problem. Say, for you, please calm down. Take some water, please. Please. Slowly we'll go. Absolutely no problem. Have this, please. Good at. Thank you. Thank you.
Thank you, sir.
So, last occasion you said something. We may continue from there, please. When did you get...
So I got married 30 years back.
30 years back. Oh.
And so because of this, there's been a lot of problem at home, sir.
So, because of this habit, as you said,
Yes, sir.
you're meeting so many problems in your
Yes, sir.
house.
That's it.
Okay. So, now, this is how please, thank you. This is how the empathetic approach develops. Then slowly, the party will start talking so many things. Then here within, there are umpteen number of techniques of questioning. How we'll have to question the party. Not like, what do you want? How many years you got married? Not like that. So the way in which, you believe it or not, there are more than a minimum to understand. There are 10 types of questions. There are 10 types of questions. We know only 2 questions, affirmative and negative. We are not aware of other questions. There are more than 10 types of questions. Below slowly we can bring the parties to the position. So by that what we are doing, the big challenge is, so this is one of the important challenges. So we'll have to learn the thing that we must be empathetic. We must be empathetic. The empathetic approach is the approach by which We are stepping into the shoes of the party and feeling the pain, but we are not involving. It is a very difficult task. Very difficult task. You understand that? We are getting into the shoes of the parties. We are feeling. True mediator can be one of the best mediators if he is able to mediate his daughter's problem. A mediator is not supposed to do his daughter's problem, but still, what I am saying is that if a mediator is expected to, without any emotions, if a mediator is able to deal with the problem of his daughter, then he will be one of the best empathetic mediator. So this is one of the biggest challenge both the lawyers as well as the mediators are now facing. Even the trained mediators may not be in a position to understand this systematic thing when we are doing this mediation. Appa, husband and wife, all these things will be there, ma. You have to adjust. You know, my family. Would you understand your family? One of the things you know that 20 years, the husband and wife, they have a living of 20 years. Then 5 years they are separated. Now the matter is in mediation. The wife came. For all the 5 sittings, 6 sittings, the mediator was taking a step. It was not possible. Then one fine morning, in the private session, the wife came and said, "Sorry sir, I am interested to join with my husband." "What, ma? For all these 5 sittings you said that you are not interested in your family life. Now you are suddenly saying that you can go with your husband. What's this?" "No problem, ma. It's up to you. If you want to go, you can go. That is the thing we want." Then anyway, however, may know why. "Sir, I have lived with him for 20 years. I cannot get marry another man and train him for another 20 years. So that is the thing, you know. So therefore, the thing is that how we are taking this matter with the empathetic view is a view being learned by mediation process only. Then, one more important challenge is as the Honorable High Court Judge said, it is a paradigm shift. How many you will be definitely feeling how it is a paradigm shift? Now, one 72 years old man in Viluppuram, I don't want to say his name, he came to the mediation training with all white and white, completely polished, no shoes. There. 1, 3, 4, 3 rows. He was sitting in the 3rd row. His sitting posture is like this. With the white and white, he is sitting like this. So, what does this sitting posture denote? That means, I know everything. What you chotawalas are going to teach me. That is a sitting posture, no? First day, you see the change. First day it is over. First day this hand, no, this hand has come like this. Second day, this leg has come like this. Third day, he leaned forward. Fourth day, has come to the edge of the chair. Fifth day, he shifted his seat to the first row. Then, fifth day, valedictory. So, the director is asking, can anybody give the comments of these trainers? Any two of these I want. Sir, I am coming, sir. So, I will be the first person, sir, to give the comment of the trainees, sir. Trainers. Okay, you come. Now, he was on the stage. Now he's speaking. Let us please see his posture. Sir, it was his posture. Sir, had this training been given, sir, had this training been given 20 to 25 years back, I would have spent at least 30 minutes every day with my wife. So now it is too late. However, sir, I feel so sorry. In this beginning, I was thinking that what these people are going to teach me. Now I felt so, sir. So really weeping. That was actually the magic of the training. So every advocate will definitely see, what big training. Once you go into that, they will catch you. Who? The trainers will catch you. And they will definitely transform your mind slowly. There's a clear case of transformation takes place. Now, let us see how does the transformation takes place. Can anybody say that what is learning? Can anybody say what is learning? Sir? Taking new things or reading or understanding new things. Very good, sir. So training is, some stock is already there. We are adding something more by reading, by hearing, by observations, all these things, by so many other communications, we are adding something. Then what is training? What is training? Sir? Yeah, shifting the knowledge to others is training, sir says. Learning. Training. Training is not unlearning. Sir? Yeah, training must be given from the practical experience. Learning is, as madam correctly said, that's known to unknown. Then known to unknown in practical sense is training. See, a perfection on the particular field by taking a practical way. That is called training. So that is why it's a mediation training. It's not mediation learning. Because so many other things are there. We are bringing you to that pool and you are giving a specific training on that for doing some job. So, yes, as sir rightly said, so far we have learned so many things and we have a stock in our mind. That is learning. I challenge you. We must, including myself, we must unlearn many things. What is true? What is that? So you are saying that what you are saying is wrong. How can? I added by my 35 years or 40 years, 50 years of experience, I added so much things. My head is little bigger now. Then how can you say that unlearn? What is unlearned? Therefore, our stock so far is, jocularly, we were in 14 law chambers in the High Court. Originally, our chamber was 14 law chamber. One humoristic advocate will say that, sir, you know one thing? If anybody asks inside the campus, sir, where the Indian bank is, right? The question from the ordinary man is, where the Indian bank is, that is within the premises of the High Court. Where the Indian bank is, then he will slowly take this person to the chamber. Sir, for that, it is better will we file a writ petition under section 226 and find out, sir. Sir, this is a way. So this is a way we are trained. Therefore, what we have already in our mind, even though it is a humor, what we have already in our mind cannot be erased so easily. Cannot be erased so easily. I'll straight away come to you. You Google out later. We have an expert from Lebanon. Is Nassim Taleb. Nassim Taleb. He found out a theory called black swan theory. What is the color of the swan? Everybody will say in chorus that it is white. He found out a theory that is a black swan theory. He took his theory to Australia. In Australia, people chased him away. What nonsense you are saying? The swan? black in color? No, definitely not. How can we accept that? Then thereafter, he practically took a black swan and demonstrated to the Australian people, Baba, see here, there are black swans also. So, we have a stock. This is right. We have a stock. My way is highway. Therefore, what I am telling you that to unlearn only that portion. See, everybody will be having a practice that will be going the bus, More than 75% of the people will be having an idea that will be going by bus. When you enter in the bus, you will first see whether that particular seat you use seat is vacant or not. Accept me. When you enter in the bus, you will see first your accustomed seat, the seat which is acquainted to you to see side here and there, all these seats, that particular seat is vacant or not. If that seat is not vacant, with strain, you may go in search of another seat. This is the thing. Why? Because the man is normally accustomed with what he learned already. Therefore, a new idea will not come into your mind. Every person who is entering into the bus, the next stopping will be the stranger to the man who got into the previous stopping. You feel that? Every man will be a stranger. So you traveled only 2 stoppings. Then the man who is entering the next stopping will be a stranger. You will be seen like that. You were also seen by like that only, by that earlier people. So this is actually a thing. Therefore, what we are saying is that you just throw it away. Don't make any stock. Allow new ideas. You will be having so many things. There are black swans. Don't think that my stock is the only thing. So, first we have to unlearn. So, some time ago, some 50 years ago, love marriage was not accepted by anybody. Now, if love marriages are not there, it is not being accepted by anybody. That is the way. So, because slowly we are accepting the change. Yesterday, what had happened? The 5 days training. The first day we said, myself and our Delhi trainer, we were saying, no, sir. Next day when you come, you must change your seats. So that you can try to accept the change. So your friends may be new. Something, how you are going to deal with that? Very intelligent advocate. You believe it or not, they were in a complete row. We said only to change a seat. They lock, stock and barrel. Completely all the 5 persons came in this side. Sir, you said only to change a seat, sir. We changed. See how people are thinking differently. So you are not able to change it. It does not mean that we are in the mediation principle. Therefore, you must accept the change. Therefore, you get new friends. That is the reason. Anyway, the point is, we are not able. It will be very, very difficult to accept a change. Therefore, what I am requesting you is to unlearn that non-acceptance. Otherwise, it will be very, very difficult. Therefore, learning, unlearning, then the new stock will relearning, then your transformation will take place in your mind. You test when you go out. Those who have not undergone the 40 hours training, you test with those persons who have undergone the training whether you are meeting the change or not. In Delhi, on the 4th day, the trainer has given an exercise. 4th day, the trainer has given an exercise to the participant. Sir, tomorrow you must say on the dais whether any change has taken place in your family. You have undergone 4 days training. Only tomorrow, only 1 day is left. So you will be going to your house today. You must say tomorrow whether any change has taken place in your character, in your family. Then the 5th day is reporting. Sir, one important change has taken place, sir, in my house. You say what? See, sir, my wife was talking, sir, for about 15 to 20 minutes. Then he came and tested me, was pinching me on my hand and testing whether I have any feeling at all. Because in all these years, I'll be reacting immediately. If he say a word, I'll say 3 words. Oh, that is the way our family things are going on. Now my wife tested by pinching whether at all you have any feeling at all. So that is a change has taken place, sir. This magical change will definitely take place in the mediation training. You can check with those who have undergone the training already. What does it mean? Those people have accepted the change. They have unlearned many things which are in their stock, which was not necessary for. So such type of unlearning would alone reform and make a transformation in you. Let us have another play. Mr. Prasad. Sir? Sir, this is a bus scenario. We are traveling in the bus. In 2 stoppings before Guntur, I am entering into the bus. So there is no seat in the bus at all, except this only one seat. Well, let us see how does it go. गुंटूर का एक टिकट. Oh, okay. Okay. Eight persons killed in Maharashtra. Ordnance factory blast. Shankaranti festival celebrated in a grand way. What is this? Mirchi. Mirchi accident. Where is cigarette? Oh, a Mirchi accident near Guntur. By a cigarette. Sir, see. A Mirchi accident. Arunachaleshwara, Arunachaleshwara.
Accident, sir. No? Famous.
Oh, yes, sir. Yes, sir. Yes, comfortable, sir. Comfortable, sir. Yeah, sir. Okay, please, sir.
Nice meeting.
Thank you, sir. Thank you, sir. Please. Okay. Bye. This is how, when a collaborative communication takes place, For the first news, he is not interested. For the second news, he is not interested. Some Gundur might be his area. Blast, he may be sympathetic. He is interested. Therefore, what happened? That open space. First, he occupied the entire seat. Now, slowly it opened space. When the communication is channelized and it's acceptable by both the parties and it is collaborative nature, that will click. That is what mediation is all about. So nothing but mediation is donning. You know donning? The pant is torn. You are the donor. Mediator is a donor. It is given to you. Please don and give it. Is donning. The place where it was torn is not being seen at all. Is donning in a very beautiful way. But the mediator never claims that that is his pant. Yes, my work is over. That is the way. He must not have any attachment. When he dons, so what is conflict? Conflict is a broken communication. You think conflict is a broken communication. They are not able to do that. Then the third party neutral comes. Who is the third party neutral? Louder. Mediator is a third party neutral. When the negotiation is not possible between the parties, the third party neutral comes. Let us suppose, see another demo when the third party neutral comes. So you must have no attachment. You may be mediating a 2 rupees case. You may be mediating 2 crores rupees case. But you have no attachment on that. The parties may give a kilos of sweets. No. Don't accept all these things. If you want, if you have any gratitude, there is a mediation center, you can go and give it. I am only a sannyasi. I don't want anything. I know these techniques. You know, my head may be blank. But my head is full of tools. What tools? Mediation tools. When I am going into the mediation center, you believe it or not, my head is full of tools, different techniques. I am a tool carrier. I know how to repair. That's it. But the property is not of mine. That attached detachment will be there, and when he is able to don the communications which has already been broken between the parties, he would be one of the best mediators. Was he only donning the communications between the parties? He is channelizing the communication. Unless and until you know all these techniques, it will be very, very difficult to don. Now let us see another demo, how the third party comes. Saina. Sir, please sit there. She is a sister of me. We are fighting for our property division. I have given her, by my own earning, about 100 sovereigns of jewels at the time of marriage. In spite of that, she wants the correct division of property. Let us see how does it go. Now, understand the difference between mediation and negotiation. You please tell me whether for a negotiation mediator is necessary or not. For a negotiation, whether the mediator is necessary or not. No. No, absolutely not. For a negotiation, for a simple negotiation, mediator is not necessary. Negotiation, right from the morning till you take bed and searching your bed sheet here and there and shouting on your wife, what nonsense, why did you keep that? Till such time the negotiations are going on. I jokingly said that even in Dubai, you can only see a Muslim people, Muslim God. Where in England you may have Christian gods, where in India you may have Hindu gods. Even the gods have boundaries, but not negotiation. Negotiation is omnipresent. Negotiation takes place between the parties. Now let us see how a negotiation going on and how, when does the mediator come. The mic, you please. Saina.
Sir.
Not sir. Anna.
Brother. Tell me, brother.
I told you many times. See, our father and mother did not leave anything. Did not leave anything for us except that land. See, making all fight with my wife, I gave you 100 sovereigns of jewels at the time of your marriage. Now you are still claiming the only leftover property of our father.
Yes.
In equal portion. Anyway, I don't think that it is correct. It's up to you. It's up to you. I don't think it is correct.
No. I want that share and 50.
That's what, see, this is your character.
No.
I know, child.
No, brother. No, brother.
I know.
No.
This is your character, I know. See, whatever be the form I am taking to you, whatever be the way I am putting to you, I know that finally you will be there.
No. I want that only.
So what is that 100 sovereign? What's that? What is the meaning of it? You know the value of the 100 sovereign now?
Yes, I know.
Still you know the equal part, eh?
Yes, of course. I want that.
But one thing, I am telling you, Allah is there. See that. Don't think that I'm cussing you, but I have my...
That.
Anyway, it's up to you. Let us see.
Okay.
Now, this negotiation between the parties, there is no result. Now the mediator has taken charge. The mediator is asking, why you are weeping? Why do you want half of the share? Let us take how the mediator takes a course. Sir, please come. He is a mediator. Now the scene is in a private session.
Thank you, sir. నమస్కారం సార్. సార్ బాగున్నాం సార్.
నా పేరు దుర్గా ప్రసాదమ్మ.
సార్
నన్ను ఈ కేసుకు మీడియేటర్గా అపాయింట్ చేశారు.
సరే సార్.
నా పాత్ర ఎంతవరకు అంటే మీరు దయచేసి నా దగ్గర ఎటువంటి వర్డ్స్ కూడా అబ్యూజింగ్ వర్డ్స్
సరే సార్.
తర్వాత ఈ కేసు గత 4 సంవత్సరాల నుంచి పెండింగ్ ఉందనే విషయం మీ ద్వారానే నాకు తెలిసింది. మీరు ఇక్కడ ఎటువంటి ఏడుపు అనేది లేకుండా నేను ఎంతవరకు నేను ఇంటర్ఫియర్ అయ్యేది ఏమి ఉండదమ్మా. నేను
పాటు
పనస చెట్టు కావాలా, పనస చెట్టుకు రస్తా కావాలని నీ దావాలో లేదమ్మా. లేని విషయం నువ్వు నాకు తెలియజేస్తున్నావు ఇప్పుడు.
అవును సార్.
మరి హాఫ్ షేర్ అడిగినావు కదా, మరి ఏమ్మా నీ యొక్క అభిప్రాయం ఫైనల్గా? వై యు ఆర్ సో ఇంట్రెస్ట్ అబౌట్ దట్ ట్రీ అమ్మా?
మా అమ్మ ఎంతో ప్రేమగా నన్ను చూసుకొని, ఆవిడ ఎంతో ప్రేమగా నాకు అన్నప్రాసనకి అన్నం తినిపించి,
నీ బాధను నేను అర్థం
నేను రానతనతో ఉండి ఇప్పుడు నాతో లేరు సార్.
ఫైనల్గా ఏమ్మా నీ అభిప్రాయం ఏమ్మా? ఫైనల్గా నీ అభిప్రాయం తెలియజేస్తే నేను మీ బ్రదర్కు తెలియజేస్తానమ్మా. ఎందుకంటే సమస్య తెలుసుకునేదానికి మంచిగా సువర్ణ అవకాశం ఇది. చూడండిమ్మా, ఫైనల్గా నీ అభిప్రాయం తెలియజేయ తల్లి.
నాకు అది జాక్ ఫ్రూట్ స్థలం కావాలి సార్. మీరు మా అన్నతో మాట్లాడి ఇప్పించండి సార్ దయచేసి.
అంటే నీకు ఆ యొక్క చెట్టు దగ్గరికి రస్తా ఇచ్చి అది ఇస్తే సరిపోతుంది కదా? ఫైనల్గా నువ్వు ఊరుకుంటావా?
ఓకే సార్, సమ్మతమే.
మరి అభిప్రాయం అన్నగారికి తెలియజేయలేదా? ఎందుకమ్మా అతను నలో చేయలేదా ఆ చెట్టు దగ్గర?
వినట్లేదు సార్. ఎన్నో ఏళ్ళుగా మేము ఎంతో కష్టపడి కలిసి ఉండి దానికోసం విడిపోయినాం.
చాలా సింపుల్ సార్. మీ బ్రదర్తో ప్రైవేట్ సెషన్ చేస్తానమ్మా, నువ్వు కొంచెం బయట ఉండమ్మా.
Now it's a private session with the brother. How does it take place?
Sir, you are not allow your sister to go to the jackfruit tree because
Jackfruit tree?
Yes. Is
beyond the border?
Yes.
What nonsense, sir? See, even the half portion I am paying to give after 100 sovereigns of jewels I put, she still wants a jackfruit tree.
Yes, sir.
What, sir?
That space is also she requires.
Completely nonsensical, sir. Not sensical.
అన్నప్రాసన చేసేటప్పుడు వాళ్ళ అమ్మగారు ఆ ఆకుతో ఆమెకు అన్నం పెట్టారట. అన్నప్రాసన అప్పుడు 6 సంవత్సరాలు ఉన్నప్పుడు ఆ పిల్లకు ఆ యొక్క పనస చెట్టు ఆకుతో ఆ పిల్లకు అన్నం పెట్టిందంట మీ అమ్మగారు. కాబట్టి నాకు ఆ చెట్టు పోయే రస్తా నాకు జ్ఞాపకార్థం ఉండాలా, నాకు చిరస్మరణీయము, నా తల్లిని మెమరీ చేసుకునే దానికి నాకు అవసరం అంటుంది మీ చెల్లెలు. ఎస్ బ్రదర్, మీరు ఏమన్నా మీరు దానికి మరి ఎస్ సార్ కొంచెం ఆలోచన చేయండి కొంచెం దయచేసి.
Sorry, sir, I did not know this story so far.
అందుకే పాపం మీ చెల్లెలు చెప్పడం జరిగింది. మీరు ఏమైనా గొప్ప మనసుతో మరి కన్సిడర్ చేస్తే మీ యొక్క మ్యాటర్ మీరు ఇద్దరు కలిసి చేసి.
Then we'll do one thing. Please give me a minute's time.
Please.
Okay. I will discuss with my advocate and come.
Yes, please.
A minute's time, please. He's outside. 1 second.
Absolutely. Welcome, sir.
Sir, then that be the case. Let us suppose what my advocate says is, we can border that jackfruit tree alone and give it. Not this entire of 80 feet, 80 square feet. We border that jackfruit tree's place, let it take.
What the access, sir?
What?
Access to
access will be from her property only, sir. From her property only, access. Okay. Therefore, you border this alone and give it, no problem.
Okay, sir.
Okay, no problem. Talk to her.
From the same
talk to her. Talk to
sister
her.
also.
Okay, good. Oh yes, terminate. We'll terminate, no problem. It's enough.
Okay.
Yeah. Then,
thank you.
Thank you, sir.
Thank you, sir.
Thank you, thank you. Thank you, Saina.
I'll say some words.
మాకు కర్నూలులో 40 hours క్లాసు మీడియేషన్ క్లాసెస్ సారు చిదంబరం మన అరుణాచలం గారు తర్వాత మేడం సుధా గారు కండక్ట్ చేశారు. చాలా అద్భుతమైన క్లాసెస్. మాకు మా జిల్లా జడ్జి వారు ఎంత ప్రొవైడ్ చేశారంటే అన్ని ప్రొవైడ్ చేశారు. సబ్జెక్ట్ అంతా బాగా నేర్పించారు. ముఖ్యమైన విషయం ఏమంటే ఆ 40 hours ట్రైనింగ్ అయిన తర్వాత 40 సంవత్సరాల నుంచి తెగని ఒక నంద్యాలలో ఒక కేసు, చరిత్ర కేసు అది. ఏమయ్యా అంటే నంద్యాలలో ఆర్టీసీ బస్టాండ్ ప్రక్కన ఒక హిందూ బరియల్ గ్రౌండ్ ఉంది. ఆ హిందూ బరియల్ గ్రౌండ్కు మన యొక్క హిందువులు శవాలను తీసుకుపోయేదానికి 40 సంవత్సరాల నుంచి అక్కడ ఆటంకాలు, ఆటోలు, రిక్షాలు, తర్వాత వచ్చేసి మంచాలు, రోడ్డు మీద వండుకోవడము, బండ్లు పెట్టడము, చాలా దుర్భరమైన పరిస్థితి ఉండింది. అప్పుడు నేను ఏం చేశాను అంటే ఈ యొక్క మీడియేషన్ క్లాస్ అయిన తర్వాత ఎస్పీ గారికి, కలెక్టర్ గారికి, కమిషనర్ గారికి, మా బాధలన్నీ, హిందువుల బాధలందరూ ఆ యొక్క శ్మశానానికి పోయేదానికి మోసుకొని పోవాలంటే కూడా చాలా ఇబ్బంది. వైకుంఠ రథాన్ని కూడా అలౌ చేసేవారు కాదు. అటువంటి దౌర్భాగ్య పరిస్థితుల్లో ఉంటే వారికి ఇన్ఫామ్ చేస్తే వాళ్ళు పలకలేదు. నేనేం చేశానంటే పిఎల్సీలో అది కేసు వేశాను. వాస్తవంగా పిఎల్సీ కిందికి రాదు అది. అయితే కొంచెము టెక్నిక్ ఉపయోగించి పిఎల్సీ ఫైల్ చేసి అధికారులందరినీ పార్టీలుగా చేరుస్తే వాళ్ళందరూ కోర్టుకు రావడం జరిగింది, ఇన్ఫర్మేషన్ ఇవ్వడం జరిగింది. ఎంక్రోచర్స్ ఎవరెవరు ఉన్నారో వాళ్ళందరికీ కూడా నోటీసులు ఇవ్వడం జరిగింది. నాకేమైందంటే వాళ్ళందరూ అడ్రస్లు వచ్చాయి, ఎంక్రోచ్మెంట్ ఎవరెవరు చేశారని. తర్వాత తహసీల్దార్ గారి దగ్గర వాళ్ళందరూ వచ్చారు, మీకు పట్టాలు లేవు, మీకు కొంపలకే ఎసురు పెడతాం జాగ్రత్త అంటే 200 మంది వచ్చి ఉదయం 6 నుంచి సాయంత్రం 6 గంటల వరకు ఎటువంటి ఆక్షేపణ చేయమని చెప్పేసి హామీ పత్రాలు రాసిచ్చారు. అది మనం ఈ యొక్క మీడియేషన్ వల్ల నేను సక్సెస్ చేసింది. వాళ్ళందరికీ కన్విన్స్ చేసి వాళ్ళందరికీ నమస్కారాలు తెలియజేసి వినయంగా విధేయంగా మీ ఇండ్లు పోవు మాకు ఆటంకం చేయొద్దండి అని చెప్పి ఆ 40 సంవత్సరాల్లో సాధించని జరగని చరిత్రను మేము ఈరోజు చేసుకొని రోజు అంబులెన్సు తిప్పుతాము, అంబులెన్స్ డ్రైవర్ లేకపోతే నేనే డ్రైవర్ అయినా తిరుగుతానని చెప్పడం జరిగింది. ఆ ప్రకారం ఈరోజు అంబులెన్స్ బాగా పోతుంది, వస్తుంది. అంబులెన్సులే కాదు వైకుంఠ రథాలు కూడా పోతున్నాయి, వస్తున్నాయి. కాబట్టి మీడియేషన్ క్లాసు చాలా ఉపయోగపడింది మాకందరికి కూడాను. సార్ అరుణాచలం గారికి, సుధా మేడం గారికి మేము చాలా ధన్యవాదాలు. మా జిల్లా జడ్జి గారు మాకు ఇవన్నీ కూడా ఫెసిలిటేట్ చేశారు. మాకు ఏసీ రూమ్స్ కూడా ప్రొవైడ్ చేశారు. అక్కడంతా కూడాను చాలా గ్రాండ్ సక్సెస్గా చేశారు. వారందరికీ మేము కృతజ్ఞతలు తెలియజేస్తున్నాం. థ్యాంక్ యూ వెరీ మచ్ సార్.
Hello. The point is, the magical question in mediation is, why? When it is asked, why do you want that? Then the whole scenario changes. No. On the date when mother was feeding for the first time the solid food, she has taken the leaf from that tree and made a spoon out of it and fed me. Therefore, sentimentally, I want that tree. So, these type of things will be possible only in mediation, particularly in private session. Now let us see another video. The Lost Day Monger. The Lost Day Monger. Please switch off the lights.
பிங்கி ஸ்கூலுக்கு டைம் ஆயிடுச்சு. ரெடியா? ரெடியா வரேன். நாளைக்கு தான ஃபீஸ் கட்ட லாஸ்ட் டே. எத்தனை வாட்டி சொல்றது? ஒரு மாசமா நான் சொல்லிட்டு இருக்கேன். யாருமே கேட்க மாட்டேங்க. ஸ்கூலுக்கு கேக்குறாங்க. எல்லாரும் சிரிக்கிறாங்க. இந்த மாதிரி ஸ்கூல்ல எப்போ கட்ட, ஏன் பிங்கி மட்டும் கட்டல அப்படின்னு. நீங்க ஏன் சிரிக்கிறீங்க? இந்த ஹெட் மாஸ்டர் தான் வந்து என்ன கேட்டாரு. நான் மட்டும் ஃபீஸ் கட்டல. எல்லாரும் குக்கர் சாரிக்கிற மாதிரி வந்து என்கிட்ட கேக்குறாங்க. நீங்க லாஸ்ட் டேட் தான் கட்டுவீங்க. எப்ப பார்த்தாலும் எல்லாமே லாஸ்ட் டேட் தான் கட்டிருக்கீங்க. நீங்க லாஸ்ட் டேட்டாரா?
என்ன நம்ம குறைஞ்சு போச்சு சொல்லுறீங்களா? லாஸ்ட் டேட் ஒரு பெரிய இம்பார்ட்டன்ஸ் இருக்கு. நமக்கு நமக்கு 10 ஹவர்ஸ் ஸ்கூல் ஃபீஸ் டைம் கட்டணும், சூப்பரா படிக்கணும், ஜாம் வரும். இப்போ வந்து ஒரு விஷயம் புரிஞ்சுக்கோ, கட்டுறோம் நீ ஸ்கூல் ஃபர்ஸ்ட் வர, நாட் ஸ்கூல் ஸ்டேட் ஃபர்ஸ்ட் வர பாத்துட்டே இரு. பெரிய ஒரே தெரியல நாளை கேட்டோம் ஸ்கூல் ஃபர்ஸ்ட் வரani ஏன் ஸ்டேட் ஃபர்ஸ்ட் வர பாத்து நான் வரேன் அது மட்டும் இல்ல நாளைக்கு கட்டி முடிச்சுட்டு மாலுக்கு போறோம்
Vicky. That's okay.
How? Two things are there. Sir, light is very urgent, but I may not be visible. So, two things are important in this short video. One, the girl is a Bharatanatyam dancer. On 5th February, yes, on 15th February, her Arangetam is going to take place in Tamil Nadu. If those happen to come in Chennai, please visit the place. That is in Vani Magal. One, the mediator must know the anger management. See, sometimes the parties may come, you believe it or not, it will be your first experience in your mediation. Just once you come, the parties may say, the advocate may say, sir, it is not necessary, sir. Can you refer the matter back to court? I said, no, I am saying that you send it back. Then the very moment, the impasse is created. The very moment the impasse is created. How will you deal with that? In spite of so many theories, then you will be blinking. How to deal with? How to overcome these things? Right? This is the thing. Now, one of the important aspects how to deal with this matter is redirect the focus from one place to other. That is very important. It is here, it is focused on two ways. One, you see, lost rate not is a question. You are studying well, you are coming as a first student, is a question. Don't worry. I'll pay the fees. Number two, right? I'll take you to the mall. Today I'll take you to the mall. Therefore, by these two things, her attention has completely been diverted in a positive way and made it possible. At the time when he goes out of the house to the school, Pinky, very good smile. So, these type of things are to be learned, can be learned only in mediation. Otherwise, it will not be possible at all. These techniques, lot of techniques are being learned by you only in mediation. So, mediation is a scientific process, sir. It will work in everybody's family. Therefore, when at the time when the next mediation training is opted, please go be a first person, take the training. You know all the nuances. You unlearn many things of these adversarial things and learn many things in mediation. Hudson Bannett said, see, if these principles have been in the offing for about more than 100 years back, we would have welcomed. He said, at first, his quotation is like this, at first, people refuse to believe that a strange thing can be done. Then they begin to hope that that can be done. Then they begin to hope that that can be done. Then they see that is done. Now the whole world wonders why it was not done centuries ago. That is actually applicable to mediation. Now we are feeling that this would have happened centuries ago. Now only India deciphered it. A lot of private mediations are encouraged in the 2023 Act. Therefore, it is now your world. It is not one door. There are multi-doors opened. It is all up to you to utilize the opportunity. Like the cases are coming, the cases will keep on coming for mediation also to you. That is the way now. Take an official training as early as possible. That is actually the awareness we are creating. In the awareness, I am telling you, we are only pained that we are not able to give you more. We are not even saying a single word as lie. That is the thing. Now, sir, that is what is that? The decoding, encoding, communication. A coffee skip, yeah.
எட்டு மணி நேரம் வேலை செய்யணும்னு சொன்னாங்க. இப்ப 12 மணி நேரம் செஞ்சுட்டு இருக்கோம். இப்ப 14 மணி நேரம் வந்து செய்யும்போது இப்ப புதுசா ஒரு CEO ஆர்டர் போட்டிருக்காரு. சரி, இந்த மனுஷனா எந்திரமா இவங்க குடும்பம் இருக்கா? என்ன இது புரியல, என்ன பேசுறாங்க?
நீங்க டென்ஷன் ஆயிட்டு இதை யோசிக்கிறதால ஒண்ணுமே நமக்கு நல்ல முடிவே கிடைக்காது.
யோசிக்க நீங்க சொல்ற மாதிரி CEO க்கு சப்போர்ட் பண்ணி பேசுற மாதிரி என்ன இது பேசுறாங்க?
போன வருஷம் இதை விட ஒரு பிரச்சனை வரும்போது நான் சமாளிக்கலையா? நீங்க யோசிச்சு நல்ல இப்படி கோவப்படுறதாலே டென்ஷனால ஏதாவது முடிவு நமக்கு கிடைக்குமா? கொஞ்ச நேரம் போய் உட்காருங்க, நான் காஃபி போட்டு வரேன். காஃபியை குடிச்சிட்டு பொறுமையா நம்ம யோசிப்போம் அடுத்தது என்ன செய்யணும் அப்படின்னு.
என்னாச்சுமா காஃபி?
எடுத்து வரேன்.
வா சீக்கிரம் வா. சொல்ல மறந்தேன், ஊர்ல இருந்து தம்பி வரனா போன் பண்ணிருந்தான். நான் என்ன
ஒரு வாரம் தானே ஆச்சு. தம்பி வரானா என்ன இருக்கும்? போன வாரம் நம்ம பிள்ளைங்களை கூட்டிட்டு வந்துட்டு வீடே தலையில மாத்திட்டு போயிடுச்சுங்க. மாணவர்கள் எல்லாம் சேர்ந்து அது 7 நேரத்துக்குள் சாப்பிட்டு கஷ்டம் எனக்கு என்ன தெரியும்? முழுசா ஆகலையே. வீடு ரெண்டா வீடு போயிடுச்சுங்க. அபார்ட்மெண்ட்லயே
13 வருஷம் அவன் ட்ரைனிங் முடிச்சுட்டு இப்ப வாரா குழந்தை கூப்பிட்டு அவரை வந்து கூப்பிட்ட போனது நேரம் முழுக்க போன் புத்தகத்துக்கு வச்சிருந்தாலே எடுக்கணும் ஏன் வருத்தப்படுறாங்க. திடீர்னு ஒரு வாரம் வச்சுட்டு வரான் எல்லாம் முடிச்சுட்டு சொன்ன பொறுமையா கேட்கறது இல்லையா? ஒரு சின்ன எப்பவுமே டென்ஷனா வாழ்க்கையில.
நாளைக்கு நம்ம யார் பிக்கப் பண்ண போறது, நாளைக்கு எங்க போறது, எப்படி வராங்க, எந்த ட்ரெயின்ல வராங்க?
10 ட்ரெயின் வருது. நான் யாரும் முடிவு 8 வருஷம் ஆகும். முடிச்சுட்டு நான் வந்து வந்துடுறேன். வீட்டுக்கு ஆபீஸ் எப்படி பண்ணு பாக்குறோம்.
வேலை இருக்கு, பர்மிஷன் கொடுங்க. லீவே கொடுக்குறேன். லீவ் கூட அவனுக்கு பிடிச்சதெல்லாம் நான் சமைச்சு வச்சுறேன். நீங்க வந்துருங்க, 2 பேரும் சேர்ந்து போய் கொடுத்துருக்கோம்.
ஓகே ஓகே. சரி, வேண்டாம் வந்து டைமுக்கு ராணுவ
நைட் உங்களுக்கு பிடிச்ச முட்டை குழம்பு வைக்கிறேன்.
முட்டை குழம்பு.
So, there is a paradigm. No problem, sir.
దయచేసి గుంటూరు జిల్లా నుంచి ఒకరు, అనంతపురం జిల్లా నుంచి ఒకరు, శ్రీకాకుళం జిల్లా నుంచి ఒకరు, ఈ మూడిట్లో 1 ఉమెన్ అడ్వకేట్ ఉంటే బెటరు. మూడు నేమ్స్ రాసి డయాస్ మీద పంపిస్తారా? తీసుకున్నావా? తీసుకో. మా స్టాఫ్ వస్తున్నారు. ఈరోజు జరిగిన ఎంటైర్ కార్యక్రమం మీద కన్క్లూడింగ్ సెషన్లో రెస్పాన్స్ చెప్పడం కోసం. సో జస్టిస్ రఘునందన్ రావు గారు వితిన్ 5 minutes వస్తున్నారు. ఆల్రెడీ గుంటూరులోకి ఎంటర్ అయ్యారు. రాగానే మనము డయాస్ మీద ఆహ్వానించి కంక్లూడింగ్ సెషన్ కూడా కంప్లీట్ చేసేద్దాం. థ్యాంక్ యూ. Sir, you please continue, sir. Justice Rao Raghunan Rao sir will come, and after arriving, he will have opportunity to, his lordship has opportunity to.
5 minutes for
just 5 to 10 minutes. You will conclude, sir. Thank you.
Therefore, so in this video. In this video, you could understand, when it is your brother, I have a curse. When it is my brother, I have a love. So there is a paradigm shift when we approach a conflict. Second thing is that, what we have learned in this, there is a big challenge among advocates, among mediators, or anybody in this matter, is we are not listening, we are not prepared to listen anybody, even after 1 minute or 2 minutes. That's the thing, our patience. Thereafter, we are not ready at all. If you say one thing, before you complete, I'll say the other thing. If my son says that my father ordered for a cycle, before my son completes, other will say that my father ordered for a car. Then the third man's son will say that my father ordered for a ship. Then the fourth man, my father ordered for an aeroplane. So this is the thing. Before you complete, for what I am going to say is not known to anybody. Just react. Therefore, please make a note of it. My listening is only to react. Always we listen only to react. No, you know that. In that training, what had happened? Something like that. So, my learner friend wanted to say something. Let us say, let us complete the thing. Let us see for what she is saying. Let us patiently listen. No, absolutely not. We are listening only to react, not to understand. This is a fundamental principle to overcome these challenges, that we are here to understand. We are listening to understand, not to react. This is the thing. Here what had happened, this is called encoding and decoding. This is called encoding and decoding. The man who formulated the thing must also formulate in a better way. Had he said that your brother is coming, the matter would have been over. Had she asked in the reply, whose brother is coming, the matter would have been over. Therefore, a sort of encoding is not also correct. A sort of decoding or receiving is not also correct. Therefore, you must understand, when the communications are going between the parties, you must make so many clarificatory questions to understand what is the meaning behind the words of the parties. Don't react. The reacting immediately is a cancerous disease, which is available in everybody. The mediation completely changes it. I am telling you, if you take 5 days of training in the mediation, never you will react. You will definitely develop the habit of patiently listening. A Chinese proverb is, tell me, I'll forget. If you tell me, I'll forget. If you involve me, I'll remember. If you tell me, I'll forget. You please involve me, I'll remember. That is a Chinese proverb. You see, mediation is involving you. How to communicate, how to listen, how to make things, how to write an agreement. All these things are being fed in the mediation. We have completely forgotten two things. What is primary and what is secondary? This is the greatest challenge we are meeting. We are not aware what is primary for us. I wanted to become a district judge. Okay, it's all right. You can do it, but all your focus must be on that. Your primary aim may be there, but the focusing is not there. But you will be harping on only buying the house and saving the money and taking the children to school. All these things will be there. But you will not be focusing on the primary issue. Therefore, always these things must be listened. What is the primary aim and what is the secondary aim? If you are not focusing on your primary aim, then you will fail. Failing to prepare. If you are not preparing well, then you are preparing to fail. If you are not preparing well, you are preparing to fail. That is the thing. Right. Now, let us see for 10 minutes or so that you can wind up. What are the roles of the lawyers in mediation? Lawyers have particularly three types of roles. When the mediation has taken place, some lawyers will say, oh, it is only mediation, it is only here in the parties you go and come, no problem, we'll see. If the mediation fails, we'll see in the court, no problem. Absolutely not. That is not. A mediation advocacy is something different. It is a very important, great study available. The lawyers must have a creative approach. This tree, lateral thinking tree. The lawyers must have a creative approach. Their brain must be always alerted. The yesterday class, I was stressing that. If you are able to find out 20 solution options at the minimum for any problem. For any problem, if you are able to analyze, if you are able to form 20 solution options, you are a good creative thinker. You will be a good creative thinker. A lawyer must have a creative thinker. See this tree. Switch off the lights. This is called lateral thinking tree. The author of this subject, lateral thinking, is Sir Edward de Bono. Sir Edward de Bono says, if you keep on digging a hole, you cannot have another hole. That is, if you want to have another hole, you must take that bore and put it in another hole. That is the only possible way. That is, there are two ways of thinking. One is linear thinking, one is lateral thinking, for our understanding. Lateral thinking is think differently, not in a routine way, thinking differently. What de Bono stresses is, if you want to have a lateral thinking, you must kill sorry I am using the word, you must kill your routine thinking. Today is Saraswati Puja, therefore we must prepare this, that. It is our routine thinking. It was routine thinking. No harm. But unless and until you have a different style of thinking, that is called lateral thinking, it will be very difficult. You compare your routine thinking with this main two branches. These two, originally these small branches are not there in the tree. You compare the original, that main two branches. These branches are routine thinking branches. Now this man is emboldened to cut those routine branches. Now thereafter you see umpteen number of protrusions. So lot of ideas, small branches. These small branches came only after cutting the routine branches. So if you are able to cut or stop your routine way of thinking, you will be getting umpteen number of lateral thinking solutions. That is why you must practice developing creative thinking. We have a lot more puzzles. We don't have time now. You must develop a sort of lateral thinking that is called a creative thinking. So that creative thinking is depicted here. One small pride of me is that this drawing is drawn by me. A small applause, right? Anyway, so the point is, don't think routinely. Start practice from today. A lawyer will have to think laterally. You must have different ideas. Ideas which could not be identified by others, you must have ideas. You storm your brain. Right, sir? Therefore, the lawyer's duty is, before going into the mediation, you must call the parties. You can charge fees for that. No doubt. When we have started practicing the mediation for about 15 years back, there was a tough fight between the lawyers and mediators. Everyone was thinking, it's coming, If he comes, that's it. There will not be any settlement. Now, you believe it or not, every mediation lawyers are coming. Lawyers are also charging for that. It is now another profession. Very good lucrative profession. Therefore, you have a wild sea. You can swim. Be confirmed. Be firm enough. You can do that. Therefore, you discuss with your client how we are going to negotiate in the mediation. Number one. Second thing, while going to mediation, while taking the parties to mediation, you participate in the mediation process. As is a demo, the man came to went to the lawyer and discussed with the lawyer for each and everything. So like that, the lawyer may be called in and he may also actively participate so that he can guide. Then, the important duty of the lawyer is, when the terms are arrived at, when the agreement terms are arrived at, he will be the sole person in writing the terms of the agreement. Do anybody have in your mind that a mediator can write an agreement? Can a mediator write an agreement? That must be an emphatic no. Don't involve you into the terms of the parties. It is only the lawyers and parties' duties to write the agreement. Only thing, lastly, you may have a vetting session. You vet it. You vet it to see that whether any illegal clauses or clauses which are not able to be executed in future, or whether the default clause is found there or not. Such type of a supervisory look can be made, but don't involve into. Any idea that whether the lawyer can sign in the agreement or not finally? Yes, no. Therefore, can sign. You are signing. Yeah, here in Andhra. Yeah. So therefore, lawyers are signing in the agreement. But in Tamil Nadu, so far we have not signed. But my question is, the lawyers cannot be called for as a witness, right? It's a simple question, an amateuristic question rather. Lawyers cannot be called for as a witness. Immunity is there. My question is, once you are signing the agreement, can't you be called as a witness? That's what I'm asking. Now, it's a clarificatory question. If lawyers are signing the agreement of the parties and counsels are signing, okay. If lawyers are signing the agreement, is not a temperament that you will be called as a witness? So in that sense, it is right or wrong? Sir? Not correct. Lawyers cannot be called as a witness. Therefore, at one side we are saying that the lawyers can never be called as a witness, but lawyers are signing the agreement. So, yes, I am telling you. The point is, so far, under section 89, or the rules, as far as our rules are concerned, there is no idea that the lawyers will sign in the agreement. Sorry, extremely sorry. The mediator will never get signed in the agreement. Mediators will not sign in the agreement. We are not signing so far. But whereas the new law says the mediator has to sign. 2023 law says mediator has to sign. But I carefully notice the word. It is said that the mediator has to, as an authentication, the mediator has signed. That is the word there. That must be authenticated by the mediator. Therefore, still, mediator is not involving himself by signing the agreement. Let us be very clear on that. Mediators are only authenticating the agreement, not signing as involving into the agreement. Therefore, we can make it and interpret in such a way. In any of the sessions, mediators are not going to be a party. It may be crores or it may be rupees. Let us be very clear. You must be in that, you are involving into that, will damage your name also. Lot more complaints are there against the mediators also. So now, then this is during mediation. Then after mediation, do lawyers have any duty? After mediation, do lawyers have any duty? After mediation, after the agreement is reached, do lawyers have any duty? Madam says that no. After agreement is reached, lawyers have no duty at all. See, voluminous duties are there even after agreement is reached. After agreement, see, if the matter is not being complied with, the lawyers have to take it to an execution. And we will have to guide the parties. How we are going to take it? All these things are the advocate's duties. The point is meticulously how the fruits of the agreement is reaching the place of
continue for 5 minutes.
5 minutes.
Then conclude.
Yes.
Good afternoon to all of you. I deem it as a privilege in inviting Honorable Sri Justice Rao Raghunandan Rao Garu, Judge High Court of AP, and the Honorable Chairman AP High Court Legal Services Committee to come on to the dais and adore the chair. I request Srimati M. Babita Garu to present the sapling to the Honorable Judge. Thank you, Madam. I request Sri M. Babita Garu to come out to the dais and adore the chair. I also request the Principal District Judge Guntur to come out to the dais and adore the chair. I also request my Master Trainer Sri Ratnatara Garu to come over to the dais and adore the chair. I also request Sri Arunachalam Garu, Master Trainer, to adore the chair.
5 moments.
I request Arunachalam Garu to continue the session.
Yeah, sorry. As a concluding, I may take 5 minutes, please. Therefore, a voluminous work is there for an advocate even after the settlement is arrived at. What is the name of the settlement as far as mediation is concerned? What is it called? Settlement agreement. It is called a settlement agreement, right? So the new law it is called a settlement agreement. Then, why do you call it the mediation as a process? Why do we call the mediation as a process and not as proceedings? Because there is no adversarial system of doing things is there. It is completely as a simple process. Therefore, in the opening statement, while we are introducing the parties, we must say 3 important things. One is that it is a voluntary process. Second thing is a confidential process. And the third thing is that, it is the pupil's domain. It is a pupil's domain. It is a determination of the parties. It is a self-determination of the parties, not the third party is deciding. These 3 things coupled with, it is not a judicial process, it is a simple process. It is a flexible process. It is a scientific process. These are all the things we must confirmly say to the parties. Then a completely overview will be taken by the parties that they will be moving and moving and moving and moving further towards a problem-solving stage. Right, sir? These are some of the important things which I would like to bring before you. Any doubts? You can ask 1 or 2 questions. Right. So ultimately, learned advocates, mediators, our primary judiciary, and everybody is moving towards a peace-making process. That is the ultimate goal of the society. Thank you very much for the opportunity.
Since from the morning, we are attending the session with regard to advantages, techniques and strategies with regard to holding mediation. In this regard, I request Srimati G. Padmaja, advocate from Anantapur, to give her response in this regard.
వేదిక అలంకరించిన పెద్దలకు, ఇక్కడ విచ్చేసంటి ప్రతి ఒక్కరికి నా యొక్క నమస్సుమాంజలి. నా పేరు జి పద్మజ. నేను కూడా ట్రైన్డ్ మీడియేటరు. నేను 2012లోనే ఈ యొక్క మీడియేషన్ మీద నేను 48 అవర్స్ ట్రైనింగ్ తీసుకున్నాను. ఆ తర్వాత అనంతపూర్ నుంచి ఫస్ట్ మీడియేటర్గా నాకు సుప్రీంకోర్టు రికగ్నిషన్ ఇచ్చింది. 10 కేసెస్ నేను కాంప్రమైజ్ చేసిన తర్వాత అదేవిధంగా 20 కేసెస్లో సక్సెస్గా నేను మీడియేటర్గా చేసినందుకు నాకు విజయవాడలో సెకండ్ టైం కూడా నేను మీడియేషన్ ట్రైనింగ్ తీసుకోవడం జరిగింది. మరి ఇలాంటి ప్రోగ్రాం రావడానికి ఇంత ఎక్స్పీరియన్స్ ఉన్నా కూడా రావడానికి ఒకటే ఒక రీజను, ఎప్పుడు కూడా ఏదైనా సరే మనము నేర్చుకుంటూ ఉండాలి. ఒక్కొక్క మీడియేటరు మనకు రీసోర్స్ పర్సన్స్ చాలామంది ఉన్నారు, చాలా చక్కగా వివరిస్తున్నారు. ఈరోజు మార్నింగ్ మేడం రత్న మేడం గారు చెప్పినప్పుడు నిజంగా 48 అవర్స్లో మేము విన్నది ఒక్క రోజులో ఆల్మోస్ట్ నాకు తెలిసి 1.5 అవర్లో మేడం చాలా ఎక్స్ప్లెయిన్ చేసినారు. అందుకు మేడంకి నా యొక్క కృతజ్ఞతలు. ఇక్కడ చాలామంది అడ్వకేట్స్ ఉన్నారు, మీడియేటర్స్ తక్కువే ఉన్నారు నాకు తెలిసి. సో మీడియేషన్ మేము 48 అవర్స్ ఉండి నేర్చుకున్నదంతా కూడా ఇక్కడ మనకు 1 డేలో వాళ్ళు చెప్పడానికి చాలా ప్రయత్నం చేస్తున్నారు. మనం చూసాం అరుణాచలం సార్ కూడా, ఎందుకంటే ఏదైనా సబ్జెక్ట్ చెప్పినప్పుడు మాటల్లో కాకుండా కొంచెం మనకు ఈ యొక్క దృశ్య రూపంలో చూపిస్తే బాగుంటుందనే ఉద్దేశంతో సార్ మనకు ఈ విధమైన చిన్న స్కిట్స్ చూపిస్తున్నారు. అదేవిధంగా అడ్వకేట్స్ని కూడా పిలిపించి ఇక్కడ ఎంతో చక్కగా మనకు ఎక్స్ప్లెయిన్ చేస్తున్నారు ఏ విధంగా ఉంటుంది మీడియేషన్ అని. ఎస్పెషలీ లాయర్స్కి మీడియేషన్ గురించి ఎక్స్ప్లెయిన్ చేయడానికి బెనిఫిట్స్ తెలియజేయడానికి రీజన్ ఏమంటే, మనందరిలో చాలామందికి అపోహ ఉంది, డిస్ట్రిక్ట్ లీగల్ సర్వీస్ అథారిటీ వచ్చిన తర్వాత, ఈ యొక్క మీడియేషన్ సెంటర్స్ అన్నీ వచ్చిన తర్వాత మా కేసెస్ అన్నీ వెళ్ళిపోతున్నాయి మాకు అసలు. ఎందుకంటే క్లయింట్స్ కూడా అలాగే ఉన్నారు, ఎందుకంటే ఐఎమ్ ఆల్సో 30 years అడ్వకేట్ ఎక్స్పీరియన్స్ ఉంది కూడా చెప్తున్నాం. కేసెస్ త్వరగా చేస్తే పార్టీలందరూ కూడా సంతోషపడుతున్నారు అంటున్నారు, కానీ చాలా మటుకు ప్రాక్టికల్గా చెప్తున్నాను సార్ నేను. ఇంకా మీడియేషన్లో కేసు అన్నీ జరిపినప్పుడు లాయర్గా మీరు కేసు చేసింది ఏముందనే విషయం పైన చాలామంది ఫీజులు కూడా మనకు రాకుండా పోతున్నాయి. అందుకోసం కొంచెం ఎక్కడో ఒక భయం కూడా ఉంది మనకు, మీడియేషన్స్ ఇవన్నీ వస్తే ఇంకా ఇబ్బంది ఏమో, కేసెస్ రావేమో అని. కానీ ఇప్పుడు కొంచెం మారింది. మేము కొత్తలో ఉన్నప్పుడు మాకు కూడా ఈ ప్రాబ్లం చాలా ఉండేది, కానీ ఇప్పుడు మేము కూడా ఏమంటున్నామంటే అడ్వకేట్స్ లేని మీడియేటర్స్ ఎవరు కూడా ఫెసిలిటేట్ చేయలేం. బికాజ్ అడ్వకేట్ ఉంటే మేము చెప్పేదానికంటే కూడా ఒక క్లయింట్ ఒక లాయర్ని నమ్మి వెళ్ళింటారు, వాళ్ళు చెప్పేదానికి చాలా వాల్యూ ఉంటుంది మేము ఎంత చెప్పినప్పటికి కూడా. వాళ్ళు కూడా మేడం వాళ్ళు మీ మంచి కోసమే చెప్తున్నారు, ఇలా అయితే బాగుంటుంది అన్నప్పుడే ఇద్దరు కూడా కలిసినప్పుడు ఈ మీడియేషన్ సక్సెస్ అవుతుందని చెప్పేసి నా యొక్క అభిప్రాయము. మంచి ప్రోగ్రాంకు మేమందరం ఇక్కడ రావడానికి ఇంత మంచి మాకు ఫెసిలిటేట్ చేసినటువంటి న్యాయమూర్తులందరికీ కూడా నా యొక్క కృతజ్ఞతలు. థ్యాంక్ యూ సో మచ్.
Thank you, Padmaja. Now I request Sri M. Kranti, advocate from Srikakulam, to come over to the dais and give his response.
సభకు నమస్కారం. వేదికపై ఉన్న ఆఫీసర్స్ అందరికి కూడా నమస్కరిస్తూ ప్రారంభిస్తాను. మాది శ్రీకాకుళం. మా జిల్లా జడ్జి గారు ఈ మీటింగ్లో తప్పనిసరిగా మీరు పార్టిసిపేట్ చేయాలి, పార్టిసిపేషనే కాదు చాలా క్రమశిక్షణతో పార్టిసిపేట్ చేయాలని కూడా మాకు ఒక డైరెక్షన్ ఇచ్చారు. వారి డైరెక్షన్ మేరకే మేము క్రమశిక్షణగానే ఈరోజు ఇందులో పాల్గొన్నాం. అయితే జిల్లా జడ్జి గారికి ఒకటి అడిగాం, సార్ మమ్మల్ని పంపిస్తున్నారు బాగుంది, మా ట్రావెలింగ్ ఎలివెన్స్ కూడా ఇవ్వకపోతే ఎట్లాగా, మేము ఎందుకు వెళ్ళాలి, ఎవరి కోసం వెళ్ళాలి అని క్వశ్చన్ చేస్తాం. మీకు ఇంట్రెస్ట్ ఉంటే వెళ్ళండి క్రాంతి గారు, లేకపోతే వేరే వాళ్ళు చూద్దాం. మీరు ట్రావెలింగ్ ఎలివెన్స్ తీసుకోకుండా వెళ్తేనే మీరు ఇంట్రెస్ట్గా వెళ్ళినట్టుగా మేము భావిస్తాం. మీరు మరిన్ని విషయాలు తెలుసుకోవడం కూడా ప్రయత్నం చేస్తారు ఆయన వారు చెప్పడం జరిగింది. అలాగే చాలామంది ఇక్కడికి వచ్చాక అర్థమైంది, ఇంతమంది హాజరయ్యారు, మీరందరూ ట్రావెలింగ్ అలవెన్స్ లేకుండా వచ్చిన వాళ్ళే. అర్థమేంటి, ఇంట్రెస్ట్గా ఈ మీడియేషన్ ప్రోగ్రాంలో పాల్గొందామని వచ్చారు. మేము కూడా అట్లానే వచ్చాం. వచ్చిన తర్వాత నాకైతే అర్థమైంది,
ఒక అద్భుతమైన మీటింగ్లో పాల్గొన్నాం. చాలా విషయాలు ఈ మీటింగ్ ద్వారా మాకు తెలిసాయన్నది మాత్రం నాకు అర్థమైంది. ఇది మా జడ్జి గారికి చెప్తాము, మా ప్రాంత ప్రజలకు కూడా చెప్తాము. ఒక డేలో కొన్ని అవర్స్లో ఇంత మంచి క్లాసుని కండక్ట్ చేసేటువంటి స్టేట్ లీగల్ సెల్ అథారిటీ వాళ్ళకి ఖచ్చితంగా ప్రత్యేక ధన్యవాదాలు మా జిల్లా నుంచి తెలియజేస్తా ఉన్నాం. రెండోది, ఈ మీడియేషన్ ఒక రాష్ట్ర స్థాయిలో జరుగుతుంది. ఇట్లాంటి సెమినార్లు జిల్లాలో కూడా జరిగితే మరింత ఫలితాలు వస్తాయి. అట్లాగే మండల స్థాయిలో కూడా జరిగితే మరింత ఫలితాలు వస్తాయి. ఇంకా శక్తి ఉంటే పంచాయతీలో కూడా స్థాయిలో జరిగితే ఒక అడ్వకేట్స్నే కాకుండా ఆ గ్రామాల్లో ఉన్నటువంటి మండలంలో ఉన్నటువంటి యువకులు, విద్యావంతులు, స్వచ్ఛంద సంస్థలు వాళ్ళకు కూడా ఈ మీడియేషన్ పైన మనం కొంత తర్పిస్తే ఈ మీడియేషన్ అనేది మరింత ప్రజల్లోకి వెళ్ళడానికి ఉపయోగపడుతుంది. ఆ రకంగా లీగల్ సెల్ అథారిటీ ప్రయత్నం చేయాలని వారికి నమస్కరిస్తూ ముగిస్తాను.
Thank you, Kranti garu. Now I request Kranti Sinha garu from Guntur Bar Association to give his response.
వేదికను అలంకరించిన ముఖ్య అతిథులకు, గౌరవ అతిథులకి, అలాగే వేదిక ముందు ఉన్న న్యాయమూర్తులకు అందరికీ ఈరోజు చాలా శుభదినం. మన గౌరవ అతిథి గారు ఈరోజు ఈ ప్రోగ్రాంకి రావటం, ఈరోజు జరిగిన కార్యక్రమం చాలా చాలా బాగా జరిగింది. ఎందుకంటే ఇదివరకు గతంలో ఆల్టర్నేటివ్ డిస్ప్యూట్ రెజల్యూషన్ సిస్టమ్ అనేది ఎంతవరకు అవగాహన ఉంది సొసైటీలో అనేది అది చాలా తక్కువగా ఉండేది. ఇప్పుడు ప్రజెంట్ ఈ 40 days ప్రోగ్రాం వల్ల కానీ ఈ రోజున్న సెషన్కి మంచి అప్లాజ్ కానీ బాగా జరుగుతుంది. థ్యాంక్ యూ ఫర్ ఎవ్రీవన్. థ్యాంక్ యూ.
Thank you, Kranti Sinha garu. Now I request Srimati M. Babita garu, Member Secretary, AP State Legal Services Authority, to summarize with regard to the program.
My pranamams to Lordship Justice Rao Raghunandan Rao garu. A very good evening to the dignitaries on the dais, my colleagues, and especially the participant advocates. Some of them are trained and some of them are inclined to train now by hearing after this session. And my colleagues and law college students, a very good evening. So, my lord, in the morning session, Ratnatara madam has taken both mediation and its benefits. And with regard to the process and techniques and effective mediation, understanding the process and techniques, my lord. And she has elaborated on that aspect by refreshing and insightful exploration of the mediation as a game-changing approach to dispute resolution from the inception from Vedic era to British time, and later on how the panchayats used to manage the mediation and resolve the disputes, and after that a structured mediation system was elaborated as per section 89. And she has highlighted the Salem Bar Association and also AFCON's infrastructure. And also delving into the benefits of mediation, the discussion sheds light on its potential to revolutionize the way conflicts are addressed. On its potential to revolutionize the way conflicts are addressed, promoting a more collaborative, efficient, and cost-effective approach. As a new paradigm, mediation emerges as a beacon of hope for resolving disputes in a manner that preserves relationship, fosters understanding, and ensures mutually beneficial outcomes, making this topic a timely and thought-provoking contribution to the field of the dispute resolution. Further, the master trainer has taken the next topic, and she has in comprehensive and in-depth examination was made out by her, and she has elaborated as to the process and technique how it has to be conducted, offering a nuanced understanding of the intricacies involved in effective mediation. Further, with regard to the districting various stages from the introductory to the opening statement, and thereafter what are the do's and don'ts, and especially how the mediation has to be dealt confidentially, and how the confidentiality has to be maintained throughout, and it has to be explained to the parties also was elaborated, and all the issues were practically and in-depth elaborated by the master trainer Ratnatara madam. And in the afternoon session, role of advocates, mediation, advocate as mediator, enhancing client outcomes. Not only theoretically, Arunachalam sir has elaborated by way of skits, demo presentation was done, that is through live and single sitting as well as joint sittings, and made different demos like how a person's attitude will be when he boards the bus and he was not given seat, and has correlated the same with how the mediator should be there, and how he has to extract, and how to unlearn things, and learning and relearning, transformation, etc., and how to be empathetic. And further, he has dealt through a skit about the partition suit, that is by way of collaboration, communication. All these skits were channelized. And further, he has elaborated in the last topic, overcoming challenges and adopting the best practices. So through practical way, how a mediation to be done was clearly explained by both the senior trainers from MCPC. Last but not the least, I would like to thank both the senior trainers for imparting practical knowledge and skits also. And you all know this program is being conducted in view of the directions of the Honorable Judges Committee. Mediators training bit serious, and they should work it out professionally. And we want to make out a few of trainers from the gathering present here. We expect that, even our Honorable High Court also expects that. So I'm very thankful to my Lord for giving me this opportunity. Namaste.
థ్యాంక్ యూ మేడం. ఈరోజు ఉదయం నుంచి మనకి ఈ మధ్యవర్తిత్వం మీద శిక్షణా తరగతులు నిర్వహిస్తున్నటువంటి మన ట్రైనర్స్ని గౌరవించుకోవడం మన సాంప్రదాయం. దానిలో భాగంగానే ముందుగా సీనియర్ ట్రైనర్ రత్నతార గారిని సత్కరించుకోవడం కోసం నేను మన మెంబర్ సెక్రటరీ ఏపీ స్టేట్ లీగల్ సర్వీస్ అథారిటీ ఎం బబిత గారిని శాల్వా వేసి సత్కరించవలసిందిగా కోరుతున్నాను. అదేవిధంగా గుంటూరు జిల్లా డిస్ట్రిక్ట్ జడ్జి గారు పార్థసారథి గారిని వారికి శాప్లింగ్ అందజేయాల్సిందిగా కోరుకుంటున్నాం. అదేవిధంగా మన హైకోర్టు లీగల్ సర్వీస్ కమిటీ చైర్మన్ శ్రీ జస్టిస్ రావు రఘునందనరావు గారిని వారికి మన స్టేట్ లీగల్ సర్వీస్ అథారిటీ తరపున ఒక జ్ఞాపికని అందజేయాల్సిందిగా కోరుతా ఉన్నాం. అదేవిధంగా అరుణాచలం గారు రెండో మాస్టర్ ట్రైనర్, వారికి శాలువాతోటి గుంటూరు జిల్లా డిస్ట్రిక్ట్ జడ్జి గారు పార్థసారథి గారిని శాలువాతో సత్కరించవలసిందిగా కోరుతా ఉన్నాం. అదేవిధంగా వారికి ఎం బబిత గారు మెంబర్ సెక్రటరీ ఏపీ స్టేట్ లీగల్ సర్వీస్ అథారిటీ వారిని శాప్లింగ్ అందజేయాల్సిందిగా కోరుతా ఉన్నాం. అలాగే ఆంధ్రప్రదేశ్ హైకోర్టు లీగల్ సర్వీసెస్ కమిటీ చైర్మన్ గారు రావు రఘునందనరావు గారిని వారికి జ్ఞాపికను అందజేయాల్సిందిగా కోరుతా ఉన్నాం. థ్యాంక్ యూ మలాడ్. ఈ కార్యక్రమంలో భాగంగా ఇప్పుడు మనందరి తరపున జస్టిస్ రఘునందనరావు గారిని సత్కరించుకోవడం కోసం బబిత గారిని శాప్లింగ్ అందజేయాల్సిందిగా కోరుతా ఉన్నాను. అదేవిధంగా పార్థసారథి గారిని పార్థసారథి గారిని శాలువాతో సత్కరించవలసిందిగా కోరుతా ఉన్నాను. అదేవిధంగా ఆంధ్రప్రదేశ్ రాష్ట్ర న్యాయ సేవాధికార సంస్థ తరపున ఒక జ్ఞాపికని మెంబర్ సెక్రటరీ ఎం బబితి గారు, అదేవిధంగా హైకోర్టు కార్యదర్శి గారిని, అదేవిధంగా
Now may I request Honorable Sri Justice Rao Raghunandan Rao Garu, Judge High Court of AP and the Chairman AP High Court Legal Services Committee to give his valedictory address.
Good evening to all of you. To start on a lighter note, I think though you are the people who have gone through this whole day's session, I seem to have come here only to receive a memento. But anyway, thank you for the memento. I will not trouble all of you by telling you how crucial or how significant mediation has now become, because experts have spoken to you about it. So I will not presume to tell you things which they have already told you. And I'm sure they would have told it in a much better way. I would only speak about two aspects of mediation, which I'm sure they have already spoken. The biggest issue in mediation, from my understanding, is the change in attitude. We have grown up in a system of adversarial litigation. For us, when we get into a litigation, the first thing we look at is how do we ensure the other side loses. Now, we need to move from that. Now, that is, I think, one of the most difficult parts for mediation to succeed anywhere in India. Because it is not just mediators who count. Quite a lot of this litigation will end in mediation only if the advocates also agree for mediation. Now, that is where all advocates are going to become important. It is not just the mediators, because a client will first take advice from his advocate as to whether he or she should get into mediation and whether he or she should accept the result of the mediation. Because in mediation, you are trying to effect a compromise. And a compromise means you are giving up something. Unless you're giving up something, there is no compromise. Now, how much will you give up, to what extent, and whether that is an acceptable result? These are matters for which the client will go back to the advocate. And that is where all advocates, irrespective of whether they have undergone training or not, would have to assist and would have to sit with their clients and convince them to go for mediation, and more important, accept the result of that mediation. Now, this part of getting all the advocates to get into this mode of thinking, I think is going to be the biggest problem. Because mediators who undergo this training know how it is good or what the problems are and why it needs to be done. For us to get to all the advocates, I think is going to be the challenge. I think that will have to be the next step. Now, this is the first part, I think, which all of us need to put our minds to, as to how we get all the advocates to get into doing this kind of settlement. as one of the speakers also said, there will also be the fear of losing fees. Now, how do we get over that is something I can't really think about, but I'm sure over time we will get to that stage about how we ensure proper compensation for the advocates, either in terms of convincing them that if this matter is settled, you'll get one more case, or maybe some kind of a advocate fee schedule being amended to say the advocates will get maybe half the normal fee. I'm not sure how we go about it, but I think that can be organized. Now, this is the first aspect of what I think is going to come up. The second issue is the numbers. We have a population of 6 crores or so. We have lakhs of cases pending, both the district judiciary and the High Court. High Court has about 2.5 lakh cases, and I think the district judiciary is close to 40-50 lakh cases. Now, when you look at these numbers, for mediation to start making an impact on reduction of these numbers, we need, effectively every third or fourth advocate should become a mediator. Today, we have about 1,000 trained mediators for the whole state. Now that number has to be ramped up. We need to look at least 20,000-30,000 mediators being trained. It may be that quite a few of them may not get any work in terms of mediation, but unless we come up with those kind of numbers, mediation by itself will not have a great impact on reduction of cases. Now that is what we need to look at. So for both these reasons, unless mediation becomes a movement, we are not going to succeed very well in really using mediation techniques to reduce our caseload. Now, these are two areas for which I really have no answers, but I can say that these are the problems that we will need to identify and resolve. I'm sure over time, quite a few of you will be able to give us those answers, and all suggestions are welcome. We will definitely look into them to see how we go about it. Other than this, to say anything more is only to repeat what the speakers and the trainers have taught you over the whole day. And I don't think any of you are interested in hearing repetitions at the end of such a exhausting day of imbibing so much of knowledge and techniques for doing better mediation. I will end with a note of thanks for all of you having sacrificed your weekend and have come from all over all corners of the state. I hope this enthusiasm for mediation will spread over to all corners, and we will have more and more mediators coming and more advocates agreeing to refer matters to mediation and help the mediators in settling issues. Thank you.
Thank you very much, Lordship, for your valuable message. Now I request Sri D.H. Amar Rangeshwara, Deputy Secretary, AP State Legal Services Authority, to propose vote of thanks.
చిదంబరం గారు, హైకోర్టు న్యాయవాదుల సంఘం అధ్యక్షుల వారిని వేదిక మీద రావాల్సిందిగా కోరుతా ఉన్నాం. వారికి భవితి గారిని శాప్లింగ్ అందజేయాల్సిందిగా కోరుతా ఉన్నాం. చిదంబరం గారు, ఏమన్నా ఒక్క నిమిషం. ఈరోజు మధ్యవర్తిత్వం మెళకువలు ఈ శిక్షణా కార్యక్రమానికి సంబంధించి వందన సమర్పణ కోసం పిలవడం జరిగింది. ముఖ్యంగా ఈరోజు ఉదయం నుంచి సాయంత్రం వరకు ఇక్కడ ఈ కార్యక్రమం జరిగిన మన రాష్ట్రంలో 145 మండల్ లీగల్ సర్వీస్ కమిటీలు ఉన్నాయి. అదేవిధంగా 13 డిస్ట్రిక్ట్ లీగల్ సర్వీస్ కమిటీలు ఉన్నాయి. అన్ని దగ్గరలో కూడా ఇట్లాంటి శిక్షణా కార్యక్రమే చాలా దిగ్విజయంగా పూర్తి చేయడం జరిగింది. ఈ కార్యక్రమం ఇట్లా పూర్తి అవడానికి కారణం మన ఆంధ్రప్రదేశ్ రాష్ట్ర న్యాయ సేవాధికార సంస్థ ప్యాట్రన్ చీఫ్, అదేవిధంగా మన రాష్ట్ర ప్రధాన న్యాయమూర్తి గారు అయినటువంటి జస్టిస్ ధీరజ్ సింగ్ ఠాగూర్ గారు వారి సూచనల మేరకు ఈ కార్యక్రమాన్ని నిర్వహించడం జరిగింది. వారికి మన అందరి తరపున కూడా హృదయపూర్వకమైన ధన్యవాదాలని చప్పట్ల రూపంలో తెలియజేయాల్సిందిగా కోరుతా ఉన్నాను. అదేవిధంగా ఈరోజు 4th సాటర్డే చాలా పనులున్నా కూడా మనకి ఉదయం కార్యక్రమం ప్రారంభోత్సవం కోసం మన ఆంధ్రప్రదేశ్ రాష్ట్ర న్యాయ సేవాధికార సంస్థ ఎగ్జిక్యూటివ్ చైర్మన్ గారు జస్టిస్ రవీనాథ్ తిలహరి గారు వచ్చి సమయాన్ని కేటాయించి ఈరోజు మనకి ప్రారంభోపన్యాసాన్ని చేసి అదేవిధంగా మనకి ఈ కార్యక్రమం ఎలా జరగాలని నిరంతరం మార్గదర్శకం చేసినటువంటి వారికి కూడా మన అందరి తరపున కూడా హృదయపూర్వకమైనటువంటి ధన్యవాదాలు తెలియజేస్తూ ఉన్నాం. అదే సందర్భంలో ఇప్పుడే మనకి మాట్లాడారు, మాకు ఎప్పుడు మార్గనిర్దేశకులు ఆంధ్రప్రదేశ్ హైకోర్టు లీగల్ సర్వీసెస్ కమిటీ చైర్మన్ గారు అయినటువంటి జస్టిస్ రావు రఘునందనరావు గారికి కూడా మన అందరి తరపున హృదయపూర్వకమైనటువంటి ధన్యవాదాలు తెలియజేస్తూ ఉన్నాను. ఈ సందర్భంలో ఇక్కడ ఒక ముఖ్యమైనటువంటి విషయం చెప్పాలి. మన హైకోర్టులో ఇప్పుడు మీడియేషన్ కమిటీ ఉంది. చీఫ్ జస్టిస్ గారు, అదేవిధంగా రవీనాథ్ తిలహరి గారు, రఘునందనరావు గారు, జస్టిస్ జయసూర్య గారు. మీడియేషన్ కమిటీ మన ఆంధ్రప్రదేశ్ రాష్ట్రంలో మధ్యవర్తిత్వం చేస్తున్నటువంటి న్యాయవాదులకి ఇస్తున్నటువంటి ఫీజు తక్కువగా ఉందని భావించారు. అదే సందర్భంలో అన్సక్సెస్ఫుల్ మీడియేషన్కి ఇప్పుడు మన రాష్ట్రంలో అయితే ఫీజు లేదు. ఇప్పుడు మనం కొంతకాలం క్రితం గవర్నమెంట్కి ఒక ప్రపోజల్ పంపించాము. సక్సెస్ఫుల్ మీడియేషన్కి ఇండియాలోనే హయ్యెస్ట్ 7,500 మన స్టేట్లో తమిళనాడుతో పాటు మన రాష్ట్రంలో కూడా 7,500 ఉండాలి అనేది ఒక ప్రపోజల్ పంపించడం జరిగింది. అదేవిధంగా అన్సక్సెస్ఫుల్ మీడియేషన్కి 2,500 రూపాయలు ఇవ్వటం జరుగుతుంది అనేది ఒక ప్రపోజల్ వెళ్ళింది. వస్తే కనుక అవి మనందరూ అడ్వకేట్స్కి ఉపయోగపడం ఉంటుంది. కాబట్టి ఇట్లాంటి కార్యక్రమాలు నిర్వహించాలి అనేటటువంటి చేస్తున్నటువంటి మీడియేషన్ కమిటీకి మనందరి తరపున కూడా హృదయపూర్వకమైనటువంటి ధన్యవాదాలని మీ చప్పట్ల ద్వారా పెద్ద ఎత్తున తెలియజేయాలని కోరుకుంటా ఉన్నాం. ఈరోజు ఉదయం నుంచి కూడా మన కార్యక్రమం ఇంత సాఫీగా జరగడానికి ఒక ముఖ్య కారణం హాలు. ఈ హాల్ ఎక్కడ ఉండాలి ఏంటని మేము అందరం ఆలోచిస్తున్న క్రమంలో గుంటూరు జిల్లా జడ్జి గారు ఈ హాల్ ఒకటి ఉందని చెప్పడం జరిగింది. వెంటనే మనం అడిగిన వెంటనే మనకి ఇచ్చినటువంటి ఈ వైద్య కళాశాల యాజమాన్యానికి కూడా మన అందరి తరపున కూడా హృదయపూర్వక ధన్యవాదాలు తెలియజేస్తూ ఉన్నాం. అదే సందర్భంలో రాష్ట్ర నలుమూలల నుంచి ఎన్నో వ్యయ ప్రయాసాలకు వచ్చి ఇందాక చెప్పారు టీఏడిఏలు ఇవ్వకపోయినా కూడా అంతకంటే ఎక్కువ జ్ఞానాన్ని సంపాదించాం, విజ్ఞానాన్ని మేము అందుకున్నామని భావిస్తూ ఉదయం నుంచి సాయంత్రం వరకు కూడా అట్లాగే కూర్చొని వీటన్నిటిని ఫాలో అయినటువంటి రాష్ట్ర నలుమూలలు వచ్చినటువంటి న్యాయవాదులైన మీ అందరికి కూడా మా అందరి తరపున హృదయపూర్వకమైనటువంటి ధన్యవాదాలు చెప్పడం కోసం పెద్ద ఎత్తున చప్పట్లలో తెలియజేయాల్సిందిగా కోరుతూ ఉన్నాను. అదే సందర్భంలో ఈ కార్యక్రమం ఇంత బాగా జరగడానికి ఏపీఎస్ఎల్ఎస్ఏ మెంబర్ సెక్రటరీ గారు భవిత గారు, అలాగే గుంటూరు జిల్లా జడ్జి గారు పార్సారథి గారు, హైకోర్టు లీగల్ సర్వీసెస్ కమిటీ సెక్రటరీ గారు మాలతి గారు మనందరికీ సహకారం అందించారు. వారికి కూడా మనందరి తరపున కూడా హృదయపూర్వకమైన ధన్యవాదాలు తెలియజేస్తూ ఉన్నాం. అట్లనే ఈ కార్యక్రమానికి స్టూడెంట్స్ కొంతమంది వచ్చారు, స్టూడెంట్స్కి కానీ లేకపోతే ప్రింట్ అండ్ ఎలక్ట్రానిక్ మీడియా. అదే సందర్భంలో ఈ కార్యక్రమం ఇంత బాగా ఏర్పాటు చేయడానికి గుంటూరు జిల్లాకు సంబంధించినటువంటి కోర్ట్ స్టాఫ్ కానీ, లీగల్ సర్వీస్ స్టాఫ్ కానీ, హైకోర్టు, ఏపీఎస్ఎల్ఎస్ఏ కోర్ట్ స్టాఫ్, అదేవిధంగా పోలీస్ సిబ్బంది, ముఖ్యంగా ప్రింట్ అండ్ ఎలక్ట్రానిక్ మీడియా వారికి కూడా మా అందరి తరపున హృదయపూర్వక ధన్యవాదాలు తెలియజేస్తూ ఉన్నాం. ఈరోజు మార్నింగ్ ఉదయం నుంచి సాయంత్రం వరకు ఇప్పుడు జరుగుతున్న కార్యక్రమం అంతటిని కూడా లైవ్ స్ట్రీమింగ్ చేస్తూ ఉన్నారు. వారికి కూడా మన తరపున హృదయపూర్వక ధన్యవాదాలు తెలియజేస్తూ ఉన్నాం. సో ఈ కార్యక్రమం ఇంత బాగా జరిగిన అందరికీ కూడా ప్రతి ఒక్కరికి హృదయపూర్వకంగా ధన్యవాదాలు తెలియజేస్తూ, అదేవిధంగా మేము చూడలేదు సార్ చిదంబరం గారు, సో మన్నించాలి, వారికి కూడా మా తరపున హృదయపూర్వక ధన్యవాదాలు తెలియజేస్తూ ఉన్నాం. ఈ ఇందాక మేమంటూ ఉందా, సో వారికి శాలువాని ఆనరబుల్ జస్టిస్ రావు రఘునందనరావు గారిని వేయాల్సిందిగా కోరుతా ఉన్నాం. చివరిగా లాస్ట్లో ఈ కార్యక్రమం అంతా ఇంత బ్రహ్మాండంగా జరగడానికి మనల్ని పొద్దున్నుంచి కూడా చాలా బ్రహ్మాండంగా ఈ మీడియేషన్ మీద మనకి ఎట్లాంటి బోర్ లేకుండా కూడా చాలా వివరాలని కూలంకషంగా చెప్పినటువంటి మాస్టర్ ట్రైనర్స్ ఎవరైతే ఉన్నారో రత్నతార గారికి, అదేవిధంగా అరుణాచలం గారికి మీ యొక్క చప్పట్లతోటి ఇంకా ఇంకా హృదయపూర్వకమైన ధన్యవాదాలు మా రాష్ట్ర న్యాయ సేవాధికార సంస్థ తరపున, మీ తరపున, మనందరి తరపున తెలియజేసుకుంటూ, ఈ మధ్యవర్తిత్వం అనేది నలుదిశలా ఒక మూమెంట్ లాగా వ్యాప్తి చెందాలని కోరుకుంటూ నాకు ఈ అవకాశం ఇచ్చిన అందరికీ కూడా ధన్యవాదాలు తెలియజేస్తూ ఉన్నాం. సార్ ఇప్పుడు ఇది అయిపోయిన తర్వాత స్నాక్స్ బయట అరేంజ్ చేయడం జరిగింది, హై టీ అండ్ స్నాక్స్, ప్లీజ్ హ్యావ్ ఇట్. సార్